Wait, Vijay Lordship.
Just.
Well, may I
Yes.
be permitted to move an Milord urgent petition tomorrow, Milord?
Tomorrow.
The subject matter is the petitioner is an Australian national, Milord.
Hmm.
Now he is basically an armed wrestler. Now he came to India with a visa, but visa is expired. Meanwhile, he has applied for extension, and the authority have informed me that it is under process. In the meantime, my lord, the extra quit India notice has been issued. Number one. Number two, my lord, he is having a high BP, my lord. At this stage, he is not fit to travel. My prayer is, my lord, till 13th, I want to stay in India. July, thereafter, it is that matter. Tomorrow, my lord.
The senior bench also. Just wait, huh?
Milord. Milord, all residuary matters not which are not otherwise specified comes under dispense.
Practice is now is if there is a senior bench, same bench of senior
Lordship
bench.
is senior.
Okay,
Honorable Justice Kaushik Goswami is another.
bench 5. Bench 5.
4 and 5.
No, it's okay, but then any other senior bench? Justice Arun Dev Chaudhary is also taking up
But
bench 5.
for tomorrow, Milord, DB, his Lordship is sitting in DB.
Okay.
Diploma.
Praying for listening of this matter tomorrow for withdrawal.
Hmm.
Yes.
Yes.
With the concept of the address settlement, I beg to mention item number 9.
9.
9. I am
Yes.
for the petition on this side. Well, matter will come up after 3 weeks.
Why?
Well, there is a land acquisition matter.
Hmm.
I have to obtain instruction as regards the present status.
Mr.
He has it.
He has learned counsel for the petitioner fresh floor and is granted 3 weeks time to obtain instruction.
Well, public.
With the concept of other side, I beg to mention item number 16.
16.
Yes, sir. I am appearing for a response of 4, 5, 6, and 7. Oil
Ah.
Limited. I have prepared the affidavit in operation and sent the same for vetting also.
On the prayer of Mr.
K. Korita.
K. Kodita, learn standing counsel.
I am appearing for a response of 4, 5, 6, and 7.
Standing counsel or
Yes,
what?
yes.
Standing counsel All India Limited
Yes, sir.
for respondent number
4,
4, 5, 6, and 7. List this matter after 3 weeks so as to enable him to file affidavit of his.
May please, Lordship. Item number 12, make it adjourned for that day and make it taken up after 3 weeks, Lordship.
Why?
Actually, the item has become infractuous, Lordship.
Huh?
The item has become infractuous.
Then we'll close it.
It can be disposed of also.
Hmm?
You may kindly be disposed this case also.
Infractions.
Yes, Lordship.
Mr.
M. Rahman on behalf of M.H. Ahmed.
M. Rahman,
M. Rahman.
learned counsel, appearing on behalf of Mr.
M.H. Ahmed.
M.H. Ahmed, learned counsel for the petitioners, submits that the matter has, the writ petition has become infractious. Accordingly, writ petition is still closed on having been become infractious.
Obliged.
Your Lordship, with the consent of other side, I beg to mention item 2.
Hmm.
Your Lordship, you need to file affidavit.
What affidavit?
Authoritative opposition. Yes.
What is the matter about? Who is for petitioner? Have you taken consent?
Yes, sir.
On the prayer of MS
Yes, Borwa.
S. Borua for
Bhargav Das, Standing Council APDC.
appearing on behalf of standing Mr. P. Das.
P. Das.
B. Das, learned standing APDCL. Come on, list this matter after 3 weeks so as to enable the respondent APDCL to file affidavit in the case.
I beg to mention 18, my lord, item with consent of the other parties here.
rejoinder affidavit is prepared, but I cannot brought it today. So my lord, if they adjourn, then I think
On the prayer, Mr.
MJ Baru.
MJ Barua, land counsel for the petitioner. List this matter after 3 weeks, 2 weeks, so as to enable him to file affidavit in reply.
Lordship, I appear for respond numbers 1, 2, and 3.
Mr.
E. Bora.
D. Bora, land standing counsel.
The council, on behalf of Mrs. R. Bora, standing council NHA,
For respondent number
1, 2, and 3.
1, 2, and 3 is present.
May it please, my lord, my lord, with regard to item 11, my lord, has become infructuous. My lord, I want to withdraw the same.
Mr.
PR sort of.
P.R. Sharma, land counsel for petitioner, submits that the matter has, the writ petition has become in process. Accordingly, writ petition stands closed on having been become in process.
Obliged.
May I please,
Yes.
with the consent of other side, I beg to mention item number 6 proceed. In this matter, we need some time to file our rejoinder.
What?
We need some time, Lordship, to file our rejoinder.
Rejoinder.
Yes, Lordship.
On the prayer of Mr.
Yes, sir. Lord.
S. Sharma, land counsel for the petitioner. List this matter after 3 weeks so as to enable him to file affidavit in reply.
Obliged.
May I please, say, lordship?
Hmm.
I beg to mention for listing of one writ petition, new writ petition, tomorrow, my lord.
What is the urgency?
Lordship, it is a covered matter and the issue pertains to lordship without issuing GST ASMT 10. The demand cum show cause notice has been issued on us.
Covered matter.
Yes, my lord.
Let us see. There's no urgency.
Lordship, it's covered matter, tomorrow, lordship.
Let us see.
Obliged.
May it please your lordship, I beg to mention an item for urgent listing. Your Honor, this lordship, this matter was fixed yesterday before the Court of Justice Kaushik Goswami. There I had prayed for an adjournment, but the prayer of interim was not extended, Your Honor. I failed to make that prayer. There is an interim on the side of the petitioner. I am appearing on behalf of the respondent number 2 in that case. So the urgency.
So then we listed before the same bench.
Yes, Your Honor, but
Why don't you
if-
make
if
a
can-
mention?
it can be made tomorrow. Your Honor, I was informed that it should be placed before the senior judge, you being the senior judge,
Tomorrow,
tomorrow, your lordship, because it's a demolition order against which the petitioner had come before the court.
tomorrow.
Much of it.
May I please,
We
lordship?
listed, should be listed before the same bench, huh? Same bench, this one. You say give the mention memo.
Yes, Your Honor, I have this. Please, below.
May I please, lordship? I beg to mention for listing of a admission matter.
What is the urgency?
Matter is pertaining to the Van Dyke map of a land location. Matter is pertaining to the Van Dyke map of a land. The
What matter?
Van Dyke map. Van Dyke map.
Pen drive.
Van Dyke map.
I'm not getting. It's pen drive,
No, lordship, Van Dyke.
huh?
Van Dyke.
Ah. It's a English or a Hindi or Assamese word? English, eh? Okay. After 10 days. After next week, we'll see next week.
May I please it your lordship? Lordship, it's regarding item number 8. Would like to adjourn the matter for 1 week.
You want to adjourn?
Yes, no. On
You-
behalf of DJ Kapil.
You adjourn it.
Yes.
Why permission is required? You want to adjourn it?
Yes, sir.
Adjourn.
The concept of the others.
Why consent is required if you want to adjourn it?
No, lordship.
No
request-
permission is required from the court.
No, lordship.
You want to adjourn? Are you praying for adjournment or you want to adjourn?
Praying for adjournment, lord.
Huh?
Praying for adjournment.
Say so. Why it should be adjourned?
Due to some personal difficulty of the conducted council.
Okay, on the ground of Mr. Who is for?
I'm for DJ Kapil, petitioner.
On the ground that Mr. DJ Kapil has some personal difficulty today.
Lord,
Mr.
In this matter, entire matter also. there.
What is your name, please?
Arsi Alam.
Arsi Alam, land counsel, appearing on his press for listing of the matter after press for adjournment of matter. Mr. Praise the Lord, list the matter after 3 weeks.
Obliged.
May I please, your lordship, my lord, I beg to mention for listing of a motion item, my lord, regarding demolition, my lord, eviction, my lord, tomorrow, my lord.
And already demolished.
No, my lord, tomorrow we are apprehending that it may be there.
Hmm?
My lord, the last day for examination is tomorrow. And my lord, the entire exercise had been carried out in violation of the apex court order, my lord. Actually, my lordship allowed tomorrow due to some reason, my lord, it could not be rectified. That's why I'm again mentioning it, my lord.
Will impose a cost.
No, my lord, they.
Why are you traveling the mention memo, ink and paper,
No, my lord.
running here and there?
No, my lord, the difficulty is that the filing memo, the online, we have to do nowadays online first, then offline, my lord. There is a network error, we could not make the online on time, my lord. That's the problem.
Tomorrow or day after?
No, my lord, kindly tomorrow, my lord, day after, day after, my lord. Right.
Tomorrow
Alright.
for rejection.
My lord,
Tomorrow for rejection.
no, my lord. Obliged, my lord.
Lordship, sorry, my lord, actually, the earlier matter in the item number 8, interim also is there.
Interim order passed earlier shall continue.
Obliged, deeply obliged.
Item 8. Huh?
May I please, your lordship, I beg to mention item number 70, once from the list. And for the respondent number 4, my lord, I have taken consent from the petitioner side.
Hmm.
Well, some difficulty, my lord, may have after vacation last week.
On the prayer of Mr.
D. Google.
D. Gogoi. B or D?
D.
D. Gogoi, learned counsel for respondent number
4, lord.
4. List this matter after 3 weeks.
My lord, date may be time for the petition, I am not.
MS
SSCR.
SHJ, learned counsel for the petitioner is present. List on when?
After vacation.
15th maybe on.
15 July.
Deeply blessed.
Yes.
Lord, in item number.
Yes. Recollect.
May I check?
Yes.
In item number 12,
Hmm.
and they give adjournment today because my senior is out of station.
Item number 12.
Yes, my lord.
It's already disposed of. Infructus. Infructus closed. You have a reason to forget.
May I please, lord.
Yes.
In such a matter, was essentially heard by Honorable Justice, my Minister Drew Madam. And for clarifying certain points, I was directed to file an additional affidavit. Madam. There will be.
On two queries, two issues,
Sir,
two
madam.
questions.
Sir, madam.
Yes, you have filed it.
No, they are pursuing that, we have already sent the affidavit for vetting, madam. Till now, we have not received that, madam. For that, sir, let
Sir.
them be taken up after the madam.
Sir, when you are appearing, why the betting is required?
Even
Who could be above you? As a senior lawyer, who could be above you? Who will bet you? Who will bet it?
Secretary, come the PF commission.
It is you too, sir, to settle it. Not by
Already settled.
not by anybody else. You have to settle it and finish.
Let that will be, madam. Let the agenda, matter be taken up after a week, madam.
Okay. And Mr. K. Paul.
Yes.
And Mr. K. Paul, learned counsel for the petitioner. Next para. It is submitted by Mr. Ansidas, learned senior counsel, assisted by MS MDev, J. Boshia, learned counsel for the respondent 2, 3, and 4. That affidavit directed to be filed, directed to be filed by this court by an order dated 14/05/2026 has been sent for betting. List of therefore press for 2 weeks. 2 weeks time.
After 10 days, madam. After 10 days.
Press for listing of the matter after 10 days. So as to enable the respondent number 2, 3, and 4 to file the required affidavit. Mr. Prayers allow listing matter after 10 days.
Obviously.
Now, 3, 4, 5.
Civil matter. Yeah.
Well, I mean item number 3 only.
3.
Well, in this case, my lord. Already there is a order passed by the honorable court. Your lordship kindly see the order dated, my lord, 18/11/2022.
22.
22.
Right. 1811.
Oh, dear, point. So, my lord, that there is some order passed by this honorable court in that case, my lord, regarding my lord illegal construction of the my lord respond number 8 and 9. So already there is a consent order that was passed and that was not been implemented. It is not been implemented, my lord, till today. And my lord, implement means, my lord, they, that respondent authority, that means, my lord, municipality, that Gauhati Municipal Corporation, they issue so cause notice to, my lord, the person concerned. Then this file, this so cause notice has been challenged before the honorable court in the another 2 petition. So in that stage where it is there. In my case, my submission is that, my lord, which is the order passed by the honorable court, that has to be implemented, my lord. But by implementing, my lord, they are giving a so cause to the person, and now they file before the honorable court, my lord, this 2 petition. That's why this.
Pursuant to the order of this court,
my lord,
they have issued a
so cause notice,
notice that has been put to challenge in item 4 and 5.
4 and 5. Probably in 4 and 5, their counsel is not there. That's why probably they wait for time. My learned can probably appearing on 4 and 5.
Apologies, your lordship. Your lordship, I am appearing for item number 5, which is tagged with item number 3. The leading counsel is not available today due
Why?
to some personal difficulties. However, this matter has been tagged because there is a relevancy with the item number 3. So, your lordships, let the pleadings of item number 5 be completed, and accordingly
What?
it can be
What
heard
pleadings?
together.
This matter is very clear. There is a kind of consent order
Yes,
in item 3,
yes.
right? And pursuant to that order of the court, they have issued a notice. How can you challenge that?
Your lordships, this may be.
This is basically for the notice is basically for implementation of the court's order,
My lord.
is not it?
That is reflected, yes, my lord.
Then
Which court?
Your lordship, let the pleadings be.
we'll allow this in view of the order passed already 18, that is 1811,
18.
2022. We'll allow the writ petition in item 3 and dismiss your writ petition item 4 and 5. They have constructed illegally. They are
Yes,
running a hotel,
7th floor, my lord.
7th floor. They are running a hotel also. They are running a hotel
And
also.
hotel that is without any, my lord, it is a residential area that cannot be permitted.
7th floor.
And very interestingly, my lord, 3, 4 and 5, my lord. I have
There is no permission for 7th floor.
my lord. That is the whole crux of the. In fact, I cannot say anything in, my lord, 4 and 5 because I was not made part.
Your lordships,
Let us see the impugn order in item 5. Who is your senior?
your lordship,
Who is your senior?
the leading counsel for this matter is Mr. Fukan. Due to some personal difficulty, he is not available today. Let it be heard on the next date.
No, I just wanted to see. Let us see the impugn order in item 5. Yes, in item three. Item three, you are seven. Huh? Who is there? Who are you? Ah. Ah,
He has already, she has already, over my knowledge, madam, the another project was filed. That in that case, an order has passed for single construction that can be
remove.
regularized. That can be replaced.
Which matter?
Accordingly, I have filed petition. And so far, commercial part, not really commercial. I have given notice to the others. Because,
Who has constructed the seventh floor?
I don't know,
Who has constructed the seventh floor?
seven floor,
By you?
with the,
Ah. Ah, then
here, subsequently,
without permission.
without, not permission. But not started. So, but a seventh floor is not without permission. But
Then whatever the running of the hotel in the residential area, residential apartment.
So, originally, that permission was granted for commercial purpose. I declared, obtain the permission. That was commercial purpose. That's why I was the impression that hotel can be.
Your impression will not do.
My lord,
You will be regulated by the law.
Commercial purpose. That's why.
You are in
subsequent
item
Item, my lord, that is, 5, 4 and 5.
4 and 5.
Subsequently, I have to notice the tenant not to use the land, building for commercial purpose.
Hmm.
For that, I have to file one affidavit file.
Hmm.
About that fact, I have to file affidavit. I can be allowed to file affidavit. Of that fact.
Where?
Subsequently, I have given undertaking also before this one.
What is your stand?
My lord,
What is your stand?
the owner of the land.
Yes, then
I have.
you are admitting that the seventh floor was constructed unauthorisedly. I mean, without permission. Whatever, you admit that it's
Not to construct, but
it's okay. Number one. Number two, what about the hotel? Running of the hotel?
permit was granted for commercial purpose.
Huh.
It's
But how it was constructed? Ultimately, it was for commercial or residential purpose.
It was for commercial purpose.
But- Constructed.
Permission was granted.
Then
Thereafter, the court has first order that cannot be used for commercial purpose.
then
That's why I have noticed the tenant.
Ah.
The land, building for commercial purpose.
it's okay. You are supporting the case of the petitioner in item 3. Okay.
I, for that, yes, sir, I will be.
You appears to be very wise. Wise action, wise decision.
Yes, my lord, I have.
It's okay. Then in that case, your affidavit is not required. Your affidavit is not required. Let us see what is the impugn order in item 5.
Just I'm not being able to. Lordship, page number 73, next year 8.
Yes, you read second para. Madam, you read second para.
Now therefore.
Notice issued in pursuance to order by the Honorable Court so and so.
Now therefore.
That
notice of
writ petition is item 3.
Yes. Shall I read your worships?
No, I just wanted to show this so-called notice is pursuant to the order of this court. If it is order of this court, how your case is maintainable.
Lordship,
Yes.
let it be heard. tonight.
Hmm?
Fix it on Friday, your lordship, for admission here.
You want to trouble this court on Friday.
Your lordship. Let the leading counsel come, your lordship. Today he was not available due to his.
He's not around in the court premises.
No, your lordship. Due to some personal difficulty, he is not available for a couple of days.
Have you brought this order of this court, the order dated 09/11/2022 in the writ petition, in your writ petition? Sir, have they brought it? This they brought it.
Last page. Yes, it's page 81.
To 1811. No, I don't know.
911 is.
Now,
1811.
1811.
9/11.
They have annexed the 811. 1811.
Whatever 9/11.
Now, we are not in-
It is difficult for me because I am not yet party in that case.
You are the resident of that area.
Yes, we are the resident. We are resident. Resident of that building. In our case, my lord, only my lord, implementation is required. Order has already been passed by the Honorable. That's why official of your respondent have to know that.
Which for the JMDA. Hmm. After this, they have not proceeded further. GMD has not proceeded further.
Yes, madam, probably because of this petition, although there is no minor stay order. Although there is no stay order under this case. They tag it this matter, these two matter with this.
So they have not taken any action. So they think that once the court directed them to issue so cause notice,
That's enough.
then they think that it's enough. What to do? She's having some difficulty.
In sense of their she not it will be difficult, but they are convenient, I am ready, madam.
Any day.
Next week, we'll take it up next week. Heard Mr.
That big.
TJ Mahanta, learned senior counsel, assisted by Mr. DP,
If you want the one.
learned counsel for the petitioner in WPC 4389 of 2020. List of. Who is for respond number petition in item 4?
Me, Lord.
Yes.
KJ Hazarika.
KJ Hazarika.
Yes.
What do you say?
Sorry.
What is your stand?
I stand, your lordship, there was an NOC with the issue.
Do you admit that the notice which you have put to challenge is pursuant to the order of this court?
Same notice, madam. Same notice.
Don't you, or do you or don't you?
Same notice.
And you have not annexed that order also, pursuant to which you have the notice has been issued.
If it is required, your lordship, we will file it.
They are the party in this writ petition and item 4.
They are.
Conduct, conduct of the writ petition in item 4 and 5 appears to be not impressed or appreciated. See, madam, you also,
Yes.
Hazarika,
Yes.
you are the party in writ petition, item 3.
No, your lordship.
You-
I am just the petitioner in item number 4.
You are not respondent. They are not. He's not.
Yes, respondent number 7 and 8 in my case, my lord is Namba Kumar Kotoki, my lord is the builder. And my lord, the respondent, yes, my owners and builders are made part.
He's not.
Is not. They are the probably the.
I am the flat owner.
Who are you?
They are
I am
also.
flat.
Huh?
I am also flat owner, your lordship.
Flat owner.
Yes. Sir. In item number 4.
So why you have challenged that? Flat owner, but why? You are running some business there.
No, your lordship. There was an NOC which was given for the entire plot, but the GMDA, they had.
Or for commercial purpose.
No, your lordship. I am the flat owner.
How you are aggrieved?
Because there was an order for demolition of your lordship, 6th and 7th floor.
Huh?
So,
You are there.
yes. So your lordship, there was an NOC given for the entire plot, which was interpreted as which was interpreted to bifurcate the land, which would affect the FAR issue. But the NOC was given for the whole plot, your lordship.
The problem is, of course, you are not a party, but she is there. She is there. You are there. In the writ petition, item 4.
She is not there.
Item 4, she is not there.
No, no. She is only in item number 5.
No, as a respondent.
Yes. Item number 4.
Suresh Kumar Kashiwal is not there.
Pardon,
Ah,
but this builder. Absolutely implemented.
implemented. Anyway, MS
Yes. It's DDAS.
Didas, learned counsel, appearing for Mr. Arbi Fukar, learned counsel for petitioner in WPC 240 of 2024. Submits that her senior has some personal difficulty. says the senior has some personal difficulty today, therefore, phrase for a week's time to phrase for listing of the matter after a week. Mr. Mr. KG Hazrika, learned counsel for the petitioner in WPC 70082/2023 is present.
My lord, phone number 7 has already filed one petition before the GMC authority to convert the complex from commercial to.
We are not concerned. This is up to them. It's not before us, before the GMT authority only.
I'm the private respondent, my lord.
So it's before the GMT authority. We are not concerned. We are not concerned. Mr. MP Sharma, learned counsel for respondent numbers 7 and 8
Seven.
in WPC 240 of 2024. Item 5. And MS so and so learned counsel for appearing on behalf of Mr. P. Nayak, learned standing counsel GMD and GMC are present. Is spread for list this matter after a week. Wednesday. Next Wednesday.
Number 7.
But unfortunately, we have to displace our file, so I require some more time to reconstruct the.
Who is for the petitioner? No one appears for the petitioner on call.
Yes, there we go. Is there a
Next para. Mr. A. Bhattacharjee,
respondent number 1?
learned counsel, standing counsel for revenue and state revenue and disaster management department for respondent number 1 and
224.
Mr.
HK Hazarika.
HK Hazra, learned state counsel,
Proceed.
respondent 2 to 4, 2, 3 and 4 are present. Okay. Learned counsel has expired. Next para. It is noticed that on 03/12/2025, it has been submitted that the
Oh, what of it?
learned counsel for the petition had expired. Therefore, the matter was deferred to allow the petitioner to make alternate arrangement. Mr. It is I don't know who this is item 7.
Yes.
Item. However, no steps appears to have been taken by the petitioner. Next para. In view of above, comma, in such facts and circumstances, comma, a registry to issue notice to the respondents, petitioner, issue notice to the petitioner. List again after 4 weeks.
Item number 10.
Yes.
Such a matter relates to non-correction of revenue record. Also may dispose of directing the deputy commissioner to consider the representation filed by the petitioner. What happened, Your Lordship, the predecessor of the petitioner, Nasser Ali Bepari, was the owner of all total 101 bigha, 2 katha 15 lesses of land. After the sealing act come, remaining there remains only 48 bigha, 4 katha 2 lesses of land. But in the last resettlement operation, due to fault of the revenue official, the said land has been recorded as the government land. So therefore, they have applied before the authority, but nothing has been done. So therefore, this petition was filed.
Under which law you are entitled for settlement?
It is not for settlement.
This for what?
It is earlier their predecessor was the owner of 101 bighas of land.
Yes.
So after the sealing account, the 52 biggest 3 cases 13 less taken away by the government because it's more than the ceiling limit of 50 bighas. So after that, there remains only 48 bigha 4 katha 2 lesses in the name of the predecessor of the petitioners. So, but during the resettlement operation, the record was not properly corrected. So therefore, these 48 bighas also shown as the government land. So that is the grievances. They have earlier preferred an RTI application before the authority, and that is at annexure 4 page 25.
How many petitioners?
Here are Lordship.
8 petitioners.
Yes.
You are? It was by your predecessors.
Predecessor.
Ali Bepari.
Nasser Ali Bepari. He was the original owner.
Yes, Mr. Goswami.
Some representation is pending, Lordship.
Huh?
Some representation is pending before a deputy commissioner, Lordship. That may be disposed of, Lordship.
Huh?
That may be disposed of, Lordship.
Is it? Okay. Heard Mr.
Yes, Dekar.
S. Dekar, learned counsel for the petitioners.
Yes.
And also heard Mr.
Right.
N. Goswami. You are also there. N. Bodolai. Anything you want to say?
This record correction will be done by the deputy commissioner.
Okay. N. Bodolai, learned counsel for the learned standing counsel, revenue and disaster management. And Mr. N. Goswami, learned assistant counsel. Correspondence. Where is the application?
The last application is at page 29. Look. Annexure 7.
Page 29.
29.
You will file a fresh law.
By next period, filing this writ petition, the petitioners have prayed for a direction to the respondent authorities to correct the land record in respect of the land measuring 48 bighas, 4 kathas, 2 leches, covered by DAG number 93, 515, 62, 662, page 14. You take it from paragraph. That's a prayer question. Under kitchen numbers and so. Located in a village Nairelga, part 2, Moja, Safar, in the district of Dubri, Assam. The case of the petitioners. In brief, in short, come up, is that the petitioners hear it. The petitioners No, the predecessor in interest of the petitioners, namely late Nasir Ali Bepari. Was the original owner cum paternal of land measuring 101 bighas, 2 katas, 15 latches, covered by dag number 93, 515, para 2, huh? Take the dag number. 662 of 37, 654, oblique 660, 20 oblique 653, 644, oblique 661, comma 37, oblique 65. You take it from para 2, huh? Para 2. Of curtain number 247 of patta number 201, located at village Nairegla, part 2, same, huh? Revenue circle. Sapur, Moja Sapur, comma, revenue circle, Bilasipara, in the district of Dubri. And in Dubri district, comma, Sam. Next para. On coming into force of the Assam Fixation of Ceiling of Land Holding Act 1956. Out of the 101 bighas, 2 katas, 15 latches owned by the predecessor in interest of the petitioners, comma, a land measuring 52 bighas, 3 katas, 13 latches, they were declared as ceiling surplus land. List of after declaration of the aforesaid 52 bighas. Now, after such declaration, the remaining 48 bighas, 4 katas, 2 latches in the name of the predecessor in interest of the petitioners was under the position, under his position. Which was utilized for cultivation by paying the necessary land revenue. Mr. Next para. It is the contention of the petitioners that in the year 1987, when the predecessor in interest of the petitioner visited the office of the Mojadar for payment of revenues, he came to know that there's a mistake. Came to know that land measuring 48 bighas, 4 katas, 2 latches, standing in the name of predecessor interest of the petitioner has been shown wrongly. Has been shown wrongly as government caste land and record this same under KTR number 247 under DAG number 93 515 662 337 654 660 20 oblique 653 644 oblique 661 37 oblique 655 and 648 of 4 oblique 494. Thereafter, the petitioner the predecessor in interest of the petitioner filed an application before the revenue authority requesting, praying for correction of the record of rights in respect to aforesaid land measuring 48 bighas, 4 kathas, 2 leches. List of during the pendency. No, during before the land records, before the record of rights of the land could be corrected, comma, the predecessor in interest of the petitioner had expired, huh?
Yes, sir.
Leaving behind all the petitioners,
All of it.
leaving behind the petitioners list of the petitioners being a legal heirs is are jointly own and possess the aforesaid land measuring 48 bighas, 4 kathas, 2 leches by virtue of inheritance, and the said land is being utilized for cultivation till date. Listen. It is also claimed that although the petitioner, although the land is shown as government caste land, comma, the authority is still the authorities are still collecting the TOU Jedi, Tozi land revenue from the petitioner. No, it was collecting the Tozi land revenue from the petitioner. However, from the year 2015, the authorities has stopped receiving the revenue from the petitioners. 2015.
Tozi.
Tozi revenue.
Yes.
The petitioners have filed, the petition number 1 has filed a representation before the respondent authorities. No, list of next para. The petitioner received the information on the Right to Information Act, wherein the respondent authorities had clearly stated that land measuring 101 bighas, 2 kathas, 15 leches was standing in the name of Nasir Ali Befari. And after fixation of ceiling on Land Holding Act, there remains land measuring 48 bighas, 4 kathas, 2 leches under Katian number 248 of village. So it's the same, huh? You just write. In the name of Nasir Ali Befari. Mr. The petitioners thereafter submitted a representation before the revenue authority, praying for correction of the Jamabandi of the Jamabandi. However, no action has been, no steps has been, no action has been initiated by the respondent authority. Mr.
Yes, sir,
Ah,
I have some instruction from the circle officer, Lordship, and he informed us that, Lordship, at present, in the office of the undersigned, possession of the land mentioning cannot be carried out under because some documents are not available in the office, Lordship.
what do you mean by that?
Lordship,
When you have they issued a notification, the information saying that it is in the name of his
that is
their,
there, but can you, Lordship, para 8,
yeah, you could have produced it. You could have allowed you to bring on record.
para 8, Lordship.
Cannot be carried out furthermore. What does it mean? Relating to correction of record, as per the concern due to inability of Van Dyke map for the year and all land observance circle under the present in the office of understand position of the land mentioned in the cannot be carried out further. What do you mean by that? You have to settle it. So if it is not, it's not possible, it just should remain like this. Cannot be. We are not denying that it doesn't stand in the name of that original owner, Patara. You have to
Can
correct.
be mentioned in the order.
Next para. Mr.
Yes, thank you.
Huh?
Yes, thank you.
As Deka, learned counsel for the petitioner, submits that from the submits that there is no dispute as regards the remaining 48 dispute there is no dispute as regards the ownership of the land
48 bigha, 4 katha, 2 less.
in respect of 48 bigas,
4 kathas, 2 less.
4 katas, 2 letters, which has been inherited by the petitioners from their predecessor in interest, namely
Nasir Ali Befari.
Nasser Ali
Bepari.
Bepari, which is supported by the information furnished to the petitioners under the Right to Information Act 2005. He submits that since the respondent authorities has failed to consider the representation dated 03/05/2023 filed by the petitioners. Petition number 1,
Yes, Lord.
Ismail Hussain,
Issue.
is the
Petition number 1.
comma. The respondent authorities may be directed to consider and dispose of the representation by correcting the right of records
Right.
in the Jamabandi in the name of the present petitioners in respect of the by restoring the old Katian number 247. Mr. Next para. Mr. N. Goswami, while not objecting to the prayer for direction to dispose of the representation, on instruction submits that the circle officer, Bilasipara, revenue circle
Yes, very much.
has in fact initiated for correction of the correction of record. However, due to unavailability of Van Dyke map, BANDYEK map for the year 1960 9 to 61, and all land records of revenue village Nayaranga Part 3 under Bilasipara Revenue Circle at present in the office of the circle officer. The possession of land of the petitioners cannot be carried out furthermore. Next paragraph. Upon consideration of the materials placed on record, it is undisputed. It appears to be undisputed. It appears that there is no dispute as regards the original ownership of the predecessor in interest of the petitioner in respect of the land in question. This stuff. It is also not dispute that upon coming into force of the, what is that act?
Assam Fixation of Land Holding Act.
Assam Fixation of Land Holding Act, 1956,
56.
the land measuring 48, you remember that? 48
48 bighas,
48 bighas,
4 kathas, 2 lesses.
4 kathas, 2 acres was still under the possession and occupation of the predecessor in interest of the petitioner. Out of 101
101 bighas,
Bighas.
2 kathas, 15 lesses.
15 lakh. This stuff. It appears that the the land rights, land the right of record
Right of
in of the land has not been corrected after the coming into force of the aforesaid act, the aforesaid act. Although the remaining 48 bighas,
4 kathas, 2
4
lesses.
kathas, 2 lesses was under the possession of the predecessor in interest of the petition, and thereafter continue to be with the petitioners, which is fortified from the information furnished to the furnished by the petition, the respondent authorities to the respondent petitioners. Sorry, mistake. Next paragraph. Having considered that the length measuring 48
4 kathas, 2 lesses.
48 bighas, 4 kathas, 2 lesses is still under the position of the petitioners on by virtue of the inheritance from the predecessor in interest of the petitioners.
Nasser Ali
And-
Bepari. Nasser Ali Bepari.
Nasser Ali Bepari. And is yet to be corrected in the record. In the land record, comma, and also as agreed to by learned counsel for the parties, comma, this code is of the considered view that it would be appropriate that the appropriate to direct the respondent authorities to consider and dispose of the representation dated 03/05/2023 filed by the petitioner number 1 before the deputy commissioner, comma, Debris, sorry. Accordingly, the respondent, the deputy commissioner, Debris district is directed to consider and dispose of the representation of the petitioner. Representation for correction of the consider and dispose of the representation for correction of the land record in the name of the petitioner within a period of 2 months, 2 months from today,
Well, date of receipt to the
from the date of receipt of the certified copy of this order. Let petition stands dispose of in terms above.
Publish.
Calculate. Madam, any difficulty, you just let me know, huh? If you don't catch my thing, no? If you don't catch it, you just let me know. Huh? Just don't be quiet, because the process, I tend to lower down my voice.
Lordship, in this case, I prefer some time to file my affidavit.
Yes, what is the matter about?
Matter relating to the selling surplus land, my lord.
Huh?
My land selling surplus land. My lord, my land 390 bigha up to kotha 13 less house land, my lord, Miadi Patta land. Made selling surplus land without giving an opportunity to hearing to the petitioner, my lord.
It has been converted into government.
Yes, my lord, yes, my lord.
What is your right?
My lord, I have Patta, my lord, I have purchased my record of right, my corrected. My
It has
record
been corrected.
Yes, my lord, that is why I purchased.
We have sought an inquiry by this lordship, we have required some time.
How it was recorded?
How it was recorded, lord, because it was a.
Okay, heard Mr.
Yes, so my lord.
S. Soikia, learned counsel for the petitioner.
Yes,
One,
petitioner one.
obviously, petitioner means one. You are appearing.
I sold the land, my lord.
Oh, on the prayer of Mr. S. Roy,
2 and 3.
learned state council
Lordship, 2 and 3.
for respondents 2 and 3. Further, 3 weeks time is granted to file affidavit. Mr. A. Bhattacharya, learned standing council revenue and disaster management, and Mr. B. Patak, learned council for respondent number 4. Are present.
Okay.
May it please your lordship.
Hmm.
Lordship, I am appearing on behalf of Mr. B. Saraf. Lordship, in this matter, initially we have challenged the notifications that extended the limitation period for filing issuance of so-called
notice. Yes.
regarding force majeure, lordship. And subsequently, lordship, there is a incorporation of subsection 5 to section 16, because SOCOS proceeding was initiated in due to violation of section 16(4), but and for the financial year 1890. But lordship, in subsequently when the subsection 5 was incorporated, then then we are actually entitled to take ITC.
So,
Lordship, so this proceeding, now we are benefited from this subsection 5, Lordship, and this cannot be adjudicated by this so-called proceeding, and therefore Lordship.
no, you, when initially you filed that, challenging the so cause.
Yes,
Oh, sorry, extension of the.
yes, Lordship,
And-
because at that time, point of time, Lordship, these provisions was not inserted.
So why don't you go and approach them? When this law has changed, the provision has subsequently changed. You approach the authority. What do you say, Mr. Jain?
Subsequently, 16.5 has allowed them to take ITC.
ITC.
For the
Go
year
there.
18, 19.
What do you want to
17,
say?
18 and 19, 20. And 20.
What do you want to say?
Lordship, it is a covered matter, and same in similar matter, judgment by the coordinate bench has been passed, Lordship.
That is there.
Yes.
That is there, Lord.
Same person.
Yes, Lordship.
For what? Different
Different
district.
year.
Different year, different financial year.
Here also you are challenge. Have you approached
Lordship,
for your claim has been rejected or what?
After this judgment, their claim has been allowed.
allowed.
Huh?
Okay,
After
claim
this
has been
judgment,
allowed.
their claim has been allowed.
No, here in here present case.
Yeah, in the present
Yes,
case, their
Lord.
claim has been rejected.
Where is that order? What is the order?
Order, Lordship, page number 185, and the relevant page is 193.
185. Relevant page.
193, Lordship.
This for the year 20,
18-19 financial year.
18-19. You have also claimed for ITC in this case. Same.
Same.
Heard MS,
These are my lordship.
learned counsel for the petitioner. And also heard Mr. A.K. Jain.
KJ.
K. Jain. Learned counsel for the respondents.
Lordship.
Respondent, all respondents.
Lordship 2 to 6.
For respondent number 226. Which one?
One is CGC Lordship, Union of India.
None appears for the Union of India, respond number 1, desperate service of notice. This was a similar order.
Lordship.
Yes, sir. Similar order. This is your difference would be the amount and the date of
Amount and the year. And the proposed order in original date.
order is 15/4/2024.
15/4/2020.
15/4/2020.
22 for amount is
Amount is 28 lakhs 39,851.
yes, right here.
And penalty, lordship penalty is there.
For the period of 2018-19,
18-19 lordship, yes.
18-19.
Huh.
Here also.
Lordship.
Yes, lordship. Lordship in page 186, para 2.1, there is the financial year is
Page the 185 and 186 and 193. You check it from same order. Short order, that same order.
Much of
deeply obliged, lordship.
That arithmetic and all this thing that you will have to see. Dispose of.
Deeply obliged.
number 15.
Great decision, Lordship. Affidavits were required to be filed in this matter, Lordship.
Huh?
Affidavits were required to be filed in this matter.
It has not been filed.
Yes, Lordship.
Yes.
I am issuing for response number 567.
So you are not filing. You don't want file.
Will help.
Yes. Who else?
Required time, Lordship.
Okay. Heard Mr.
Jail authority.
J. Lothar and counsel for the petitioner. Is prayed for by Mr. S. Roy. S.S. Roy, London State Council. And 3 of you
Lordship, I am for.
and Mr.
You.
You Ghosh, London Council, were responding 5, 6 and 7. For
And
the
for
3
two.
weeks time,
And for 2.
for the 3 weeks time is granted to file affidavit in the opposition. MSN Borderley, London State Council, is standing council. Revenue and Decision Management is present. Yes,
After 4 weeks, Lordship.
4 weeks,
I'll go back.
further 4 weeks have.
Lordship, there is an interim order.
Interim order passed earlier, sir. Interim order passed earlier. Stands extended till next date.
15. Item number 19.
Has there been influxes?
Infractions. Because they had challenged the order of 2024 October for 1 month.
1 month, right?
Arrangement was for 1 month.
Yes.
That was long.
Non appears for the petition on call. Mr.
PP Datta for record number 7.
Who is for 1? Who is for 1, 2, 3? Who else are there? Mr. BJ Talukdar, London State Council.
1, 2, 3 and 4.
For respondent 1, 2, 3 and 4
5.
and 5. And
And
Mr.
PP Datta.
PP Datta, London Standing Council.
Private respondent.
London Council for Respondent 7
Seven.
are present. The challenge is to the office order office into the letter of the communication dated 18/09/2024 passed by the District Commissioner,
District Commissioner Gauhati.
Golpara, by which the respondent 7 was allowed to lift and distribute the allotted rice and food grains for the month of October 2024 within 30/09/2024. Mister, you have lifted.
That's it. That's it. Here the one interim order has been passed, debarring me from lifting. Against that, I have challenged the order before the division bench, that appeal is pending. So again, appeal, as per the stay order passed by the in appeal, read appeal, that's it. I am lifting, sir.
Okay.
I have lifted, sir.
List of. It is submitted by Mr. PP Datta, London Council for Respondent, pursuant to the order of the interim order
That's it.
passed by the division bench in division bench.
Division bench, that's it.
Ah,
Here, Lordship, in this matter, Lordship, one interim order has passed, restraining me from lifting. Against that order, I have
in pursuant to the order of the division bench.
division bench. So I am providing. Lordship.
Dated so and so, you give the in the so and so.
That's it.
The respondent number 7 has already lifted the food grains in respect of the for the month of October 2024.
That's it.
List of. Considering above, it appears that the matter has become infructuous. No, considering above, considering above and in view of the non-representation of the considering above, it appears it is seen that the matter has become infructuous for which the petitioner is for which the petitioner appears to be remain unrepresented. Accordingly, writ petition states closed as in process. We'll say so. We'll say so.
Please be made. No, see, I'm for the petitioner. The electrical APDC death case, no, see.
Electrical?
Death case, no, see.
Okay, yes.
Respondent number.
It says file an affidavit. I think they got an instruction.
Lordship may have
Who is respondent number 6?
the government. Inspector. Electrical losses.
Ah,
Electrical expenses.
who has to pay?
No. Yes, Lordship, if Lordship.
Are you
may-
for FEDCL?
Yes.
Then, ready?
My lord, there is an instruction regarding if Lordship may see page number 20,
Hmm.
clause 12. It is categorically stated that from the above stated fact and circumstances leading to the accident, it appears that the victim was unauthorizedly trying to fix and reconnect a live low voltage overhead electric service wire to his residence without informing the concerned authority of FEDC. As a result, the victim came in contact with live overhead electric service line and received fatal electric shock and such electrocution.
Hmm.
So Lordship, from here we can say that it's not our fault. It's not a petitioner's fault. It's the petitioner's fault.
You file an have you filed the affidavit?
No, ma'am.
File affidavit. We'll consider. All right. Because he's objecting.
Lordship,
He's disputing.
no, Lordship.
It's not a fault of the FEDCL.
Lordship,
I've seen it. Funding conclusion, I've seen it.
Yes, my
Heard
election-
Mr. P.G. Agrawal.
A.R. Agarwal.
A.R. Agrawal, learned counsel for the petitioner. Next para, on the prayer of Mr.
W. Ahmed.
W.
Ahmed.
Ahmed,
For
standing counsel,
234.
standing counsel,
On behalf of B. Chaudhary, man.
learned counsel appearing on behalf of Mr. B.
Chaudhary.
Chaudhary, learned standing counsel for FEDCL. Further, 2 weeks time is granted to file affidavit in
After vacation.
opposition.
After vacation.
And in that case, 3 weeks.
Okay. My- May I please, Your Lordship? My lord, the petitioner's bank account has been freezed, my lord. And here the facts of the case is that, my lord, an FIR has been lodged against some persons, my lord.
Hmm.
Lordship will find at page number 17, my lord.
Hmm.
The serial number 128. Page number 17, my lord.
Hmm. Yes.
Against these persons, my lord, an FIR has been lodged, alleging that this person has taken some loan from the Bandhan Bank,
Hmm.
giving some for identity, my lord.
Hmm.
And here, my lord, the accused number 1 and 5, my lord. Moinul Ali, serial number 1 and 5, Tabibur Rahman.
Hmm.
These two persons has previously taken some loan from the present petitioner. And to that extent, they have also executed some promissory note and money receipt, my lord.
Hmm.
So this Tabibur Rahman, when he obtained the loan of rupees 3 lakhs from the Bandhan Bank, my lord,
Hmm.
then he returned me the said amount in my bank account, my lord. So he has taken 70,000 from me, my lord. So, my lord, as the money has been taken by the Tabibur Rahman, some by fraud identity from the bank, my lord, and the said some of the amount has been transferred in my bank account. Therefore, my lord, the petitioner bank account has been freezed, my lord.
Hmm.
So therefore, I approach before this honorable court, my lord, to set aside that order, my lord, regarding the freezing of the bank account of the present petitioner. And furthermore, my lord, there is no notice or information has given to the present petitioner about his freeze of his bank account, my lord.
Hmm.
And the same has been, my lord, stated by the in affidavit, my lord, submitted by my lord, by the state, my lord, respondent number 2. This affidavit was filed on, my lord, 26th of May 2025
By whom? Bank.
by respondent number 2.
Who is respondent number 2?
My lord, the state,
State is not concerned.
my lord, the bank also filed their affidavit, my lord.
Saying what?
Banks in her additional their additional affidavit, my lord, in para number 7,
Hmm.
page number 77, my lord, they
Hmm.
stated that yes, the 72,000 rupees has been transferred in
Hmm.
my bank account from the accused number 5, that is
Hmm.
Tabibur Rahman, who has taken loan by submitting for documents, my lord.
Page.
Page 77, 77,
Hmm.
para 7, my lord.
Ah, it is 81 in fact. The read number 81. Okay, yes.
May I read, my lord?
Ah,
The internal investigation of the respondent bank reveals two transactions in the name of the petitioner. One in his ICICI bank account with a tune of rupees 4,70,000, which was transferred 10/1/2022 by one impersonated loanee Mainul Ali. That is the accused number one, and that bank account is different, my lord. The other with 72,000 in his Bandhan bank account, which was transferred on 8/3/2022 by another impersonated loanee, Tabibur Rahman. So presently, my lord, I am before this honorable court as my bank account of Bandhan Bank has been freezed, my lord.
ah,
That 72,000 rupees has been transferred. And in my petition, in my affidavit also, my lord, I have stated that yes, the amount 70,000 has been transferred in my bank account, my lord.
not
And-
72.
70,000, my lord. It is clear, my lord.
72,
It is 72.
yes. So,
So, my lord, that amount which he has transferred in my bank account, my lord, he has earlier taken some loan from the present petitioner. My lord, kindly peruse page number 23 of my writ petition, my lord.
hmm,
Page 23, my lord.
hmm.
So this is the provisory note, my lord, executed by Tabibur Rahman,
It's okay.
my lord.
It appears you are also involved.
In our affidavit, we have been clearly stated, paragraph number 6, 7, and 9, after the investigation.
He's involved.
My lord, here the case is that, my lord, the bank has filed an affidavit on that there is a presumption and assumption. My case before your lordship, my lord, that the amount,
Perhaps if they on the investigation, if there's a involvement, this is a fraud. These people are fraud. They've obtained a loan by fraud.
my lord, these people are fraud, my lord.
Fraud
Accused
customer.
Number 1 and 8.
How you are related?
My lord, I have
Are
served with
they
the
your
notice-
friends?
My lord, no, my lord, I have a society, my lord,
Hmm.
cooperative society,
Hmm,
and I gives loan to the present accused number 5, my lord.
hmm.
He has taken a loan of rupees 70,000 from me, my lord.
Ah,
And that amount has been returned back by the accused, my lord, accused number 5.
that will be, let them clear it.
My lord, my
What
submission,
is the investigation?
Well, see, the affidavit filed by the.
No, what is the stage of investigation?
My lord, as per my, it is filed on 2025.
Hmm,
My lord, on that time, not lordship, the investigation was not completed.
hmm. You
My
obtained
lord,
the,
my lord, to what, my lord, the investigation is there.
you obtained instruction.
Lord,
my lord, what,
Hey, privacy, your involvement is there.
my lord, in page number
It's
7.
very easy to say that he has taken a loan, he has returned it.
My lord, I
That
have,
is the proceed of that thing
my
only.
lord, I have
That's
served
fraud,
notice.
fraud.
In that case, my lord, in the PS case, my
I'm
lord,
not saying that now they are fraud, but appears to be. Privacy, they are fraud customers.
my lord, in the PS case, my lord,
Ah.
it has been registered against those persons.
Ah,
I have served with a notice under section 41A.
ah,
I appeared, my lord.
ah.
I appeared and I cooperated with the investigation.
Are
my
you
lord.
an accused?
No, no, my lord. I am not an accused.
Okay.
I am not
Witness,
an accused.
witness.
Yes, as the notice under section 41A has been served to me.
Let us see. Let us get the instruction. Both of you. Huh?
My lord, one more submission, my lord.
Ah,
In the affidavits filed by the state, my lord, respondent number 2, they have stated that no official correspondence was made to the accused petitioner regarding the freezing of the bank account. So, my lord, here is a violation of the principle of natural justice, my lord, because, my lord, as the present petitioner,
the principle of natural justice will not be applied to the fraudster.
my lord, here it is not established before this honorable.
No,
court
no,
whether
obviously
trial
it
can-
has not been, established, but privacy.
My lord,
There is some element of your involvement is there.
my lord, I appeared before.
Let
this
us see,
my-
let us see the status.
my lord.
You wait for when you are the party, had a connection with that, when you have received that. Maybe, I'm not saying that you are not innocent. You may be innocent,
My lord.
but the loan taken by a fraud from the bank and that that amount has been given to you, it goes to you. There's of course, the proof cannot be, proof cannot be substituted by suspicion, but there's an element of suspicion.
My lord, here,
And therefore, that will be proved by the authority. Let us see. And Mr.
Vijay Haloy, my lord.
Learned counsel for the petitioner. alloy.
My lord.
DJ alloy, huh? Land concept for reputation. Considering the nature of the issue involved as regards the freezing of bank account of the petitioner. And freezing of the bank account of the petitioner, in which the petitioner has admitted to have accepted, admitted to have received the rupees 70,000 from the from some of the accused in the alleged fraud customers of the bank, Bandhan Bank. And the petitioner, the Mr.
M. Sharma for 4 and 5.
Mr. J. Hendik, London State Council, for respondent number 2.
1, 2, and 3.
1, 2, and 3, and Mr. M. Sharma, London Standing Council for London Council for Bandhan Bank.
Yes.
Respondent number
4 and 5.
4 and 5 are directed to obtain instructions as regards the stage of investigation, status of the investigation of the status of the case, criminal case, would say
Case number,
criminal case.
Wrong PS case number lordship 62/23.
In Rangya PS case
Lordship.
number 62 of 2025.
23.
23.
May I pray for a deed once?
Yes, after 4 weeks, vacation after vacation, give that.
Highly obvious.
22.
May it be the loss.
Yes, sir.
My lord, here before the loss, the 6 petitioners of the Gauhati district, my lord, under the Balijana Revenue Circle. What happened, my lord? These 6 petitioners are the landholders of 39 acres of compact area land in the river bank, Brahmaputra, my lord. So they cultivated the last, the 2024, my lord, in the month of December, they cultivated their crops, winter crops like peas, chili, and groundnut, etc., my lord, over the 39 acres of compact area of land. Now, they were compelled to approach this honorable court, my lord, when the government issued a notice, page 83, your lordship may kindly take note of, my lord.
Yes, page
83, my lord. This is a notice issued by the respondent authority, revenue authorities, that is circle officer of Balijana Revenue Circle, whereby they install red flags prohibiting that unauthorized asking the unauthorized cultivators that they should remove their crops immediately, otherwise it will be damaged. So while installing these red flags, my lord, the government also installed flags in and around some part of the lands.
you
So
have
we
removed
appro-
it. It's
The
of
government,
2024.
the government in fact installed the red flags on the unauthorized cultivators.
No, yeah, did you remove did you harvest the
No, we did not, we approve this honorable code, my lord, the government should be restrained to not to damage our.
there's the interim order?
Yes,
Interim order is there.
my lord,
Interim order was there.
no interim order was there.
Then
No interim order was there.
2024, is say you have what is the fruits, what
No, my lord, your lordship, there was
what cultivation you have taken?
some development is there, my lord.
Yes.
What happened? After we have approved this honorable code, the authority concerned while damaging the, as per their notice, while damaging the land of the crops of the other people, unauthorized people, by using tractor and the blade. Also damaged partial land of about 10 bighas of our patta lands.
Tractor justice.
Yes, my lord. So.
Tractor justice.
Yes, but then we immediately filed a representation to the authority concerned. Already you have taken actions in respect of the unauthorized cultivators, but while doing so, they have also damaged about 10 bighas of out of our 39 bighas competitive land.
Hmm.
So we sought for we submitted representation claiming compensation of rupees 10,000. 10 lakhs. And they also admitted our patta land. They are simply telling, no, we damaged, but did not damage your crops on the patta land.
This
But
is your prayer here.
our prayer, my lord.
That is your prayer now.
No, our prayer subsequently, my lord, because of the development.
So this is your prayer here, or it's a subsequent development?
Subsequently, we have brought it before the note by way an affidavit, and we also submitted representation to the authority concerned.
No, the issue is no longer there.
No, this is not.
They have
no.
demolished, everything is removed, everything is done. You claim petition, you file a representation for damages, right?
Yes, ma'am.
Compensation, you pursue that. Nothing remains here.
All right, my.
Nothing remains here.
Of course, there nothing remains there because our
Then,
representation.
sir, if
My lord,
nothing remains there, why unnecessary we should hear
One
you?
thing, your lordship kindly listen to me, my lord. We have submitted representation. This is pending. We have brought it before the notice of this one also by annexing.
You file
the
a fresh
representation.
petition. You file a fresh
My lord, by
petition.
annexing the additional affidavit.
You file a fresh petition.
No, my lord, your lordship.
No, the main prayer is no longer there. See, there was a notice.
Yes.
Putting a red flag.
Yes.
That has been done.
Yes.
Executed.
Yes.
Better ends there. You are claiming that there are some unauthorized person. While damaging that, removing that, demolishing that,
They
some of
also
your
damaged partial portion of our.
partial portion has been. There is no dispute. They are not saying that you are no unauthorized occupant. It's not it.
No, they are admitted.
Lordship,
They are admitting that you are patadar.
Yes, yes.
we are not enterprise in the patta land. We are a government land which was they are encroaching us. We are the red flag has been that hang on there.
Where it's a government caste land.
Lordship.
Where they have encroached.
Lordship.
Better
They are
ends there.
cultivated there.
Only, my lord, your lordship.
So if you have filed a damage, that will be considered by the deputy commissioner or the appropriate authority. You file a civil suit for damage.
How can the court directly?
One thing, your lordship may be.
It is heard, Mr. No, Mr.
M.H. Raj Borboya, ma'am.
is MS
Raj Borboya, ma'am.
Raj Burburia, learned counsel for the petitioners, fairly submits that the matter has become, the writ petition has become infructuous. Although he has filed an additional affidavit, bring on record the subsequent development as regards the claim for damage of their crops.
Cross about
Cross.
10 bighas of land, madam.
Please stuff.
And we sought for a compensation of rupees 10 lakhs.
Okay.
Your lordship,
You
may
pursue
please
that.
Mention, my lord, so that we
Well,
can.
Mr. J. Hendik, you are also there. A. Bhattacharjee, learned Standing Council, Revenue and Disaster Management, Mr. Hendik, J. Hendik for state response are present. For the state council for the state response are present. Accordingly, writ petition stands closed on having been become infructuous. However, liberty is needless to observe that the petitioners are at liberty to approach the appropriate authority as regards the claim of compensation for damages of their crops as may be permissible under the law. That's all. It's not it. But we cannot.
All right.
Item number 23, 24.
Right, please, your lordships. Earlier locations.
Lordship, I have received the instruction in this case, Lordship, I will file affidavit, Lordship, 2 weeks time may be given, Lordship. I have received the instruction, Lordship.
What is your instruction?
Lordship.
NSDCL?
Yes, Lordship.
Who has to pay?
Lordship, Kala will
Well,
assess
Kala will
and
pay,
NHIDCL will pay, Lordship.
What is your stand? You are NSIDCL.
Yes, Lordship.
You are ready to pay.
No, Lordship, they are not entitled, Lordship.
Huh?
They are not entitled, Lordship.
Then
Lordship, we enter our structures about the land loss.
you have
Lordship, their structures should
yes,
have
just
submitted.
wait, just wait.
We have
You have
submitted-
received the
No,
land
Lordship.
compensation for
No,
land.
No, structures not been assessed, Lordship.
No. Have you received the land?
No.
Land is not belongs to you.
Some of them
Amendment,
received in the meantime, but some of them not, Lordship. They
Very
are
specific.
They're
Why
starting to
some?
pay.
Huh?
They are starting to pay the land compensation.
When?
But
How can that be?
as per instruction, last 2-3 months, but all are have not been got, Lordship.
Because they are not. You are not the landowner.
But
Therefore, you will not be.
about the structures of
Suppose
about the land
if you have constructed some structure
losses, but
unauthorized or illegally
no,
on a land, how can you
no,
say
in the
that?
patta land, owner authorized me.
Huh?
Owner, we got the list.
Then the owner
Section is not before this court, Lordship.
Lordship. Owner has given me on lease, Lordship. We have constructed shops.
You sought
running business.
you sought them as the
Lost.
compensation for the owner only.
Lordship.
You cannot say
I
it for.
also submitted representations also.
Yeah,
That has not been.
And Lordship, they
Lordship.
constructed, Lordship.
You are the lease.
Some of them.
You are
not
the
both.
lessee.
Some of,
You are
some
the
of-
lessee.
Some of them lessee, some are the owners also.
How do you know?
This is statement, Lordship.
Huh?
My statement is there.
See,
Yeah.
do you have the specific that who are the
Lordship, they are lessee,
landowners?
Lordship, they are not valid patta land, Lordship, but Lordship, they are the lessee, Lordship. And moreover, Lordship, they have constructed, Lordship, after publication of the 3 notification, Lordship.
That is not correct.
And
We
Lordship, they
annexed-
have no any
My lord, they asked them to
electrification or
submit
others,
affidavit.
Lordship, how then they can, Lordship,
Yes,
move, Lordship.
I have annexed them, my lord. I have annexed the.
Why you are saying some of them are the landowners? Who are the landowners? Who
Yes,
has
their
received?
names are there.
They have been received. They have received the amount
No, Lord.
compensation amount.
No.
Lordship, they are.
You cannot mix up the thing.
No,
You
Lord.
file a separate petition for the landowners if they have not
But-
been paid the
Structures not
compensation.
been assessed. Question is that Lord, the structures not been assessed. We are entitled for Jirat bill.
See, Jirat value in the sense, if you are not the owner of the land, you are the lessee
Even
only.
Lessee entitled.
Lessee, you ask from the lesser.
From the
Lordship.
assessor, Lordship.
The Lordship, not asked from them, but Lordship kindly see the section 3G. Lordship even kindly, that's also provided. And similar base also Lordship, since they are the direction to submit the affidavit will controversy, they were not entitled them. And
No,
even
in
the
certain
similar
cases,
cases,
in certain cases, affidavit is not required.
in some of the
When
cases,
first when you are not able to establish your right,
Lordship, but this honorable court.
no,
My
lessee,
lord, no.
Lordship,
My lord,
compensation
kindly-
Lessee
cannot
cannot be
processed
a-
to the rightful owners, Lordship. Compensation
No.
already processed
I
for
am-
them, Lordship.
Regarding here in the case, I am claiming for assessment of my Jirat bill. Lordship.
Jirat is,
Jirat.
you have, you may have
I am
constructed
entitled.
on the basis of the lease agreement.
Yes, Lordship.
So you claim from them
No.
as per the agreement.
Even Lordship, kindly see the words of the National Highway Authority Act, section 3G, Lordship.
Hmm.
Determination amount payable as compensation, section 3G, Lordship. 1, where any land is acquired under this act, there shall be paid an amount which shall be determined by an order of the competitive. Where the right of the user or any right in the nature of an easement on any land is acquired under this act, there shall be paid an amount to the owner and any other person whose right of enjoyment in that land has been affected in any manner whatsoever by reason of such acquisition, the amount calculated at 10% of the amount determined under section 1 of the plan. I am on that, Lordship. Even both owner also. even-
Your on that is totally misconceived.
Yes, Lordship. First, the owner will get, Lordship.
The
Then
owner.
user will come.
User means the
will
owner.
get,
Yes,
Lordship,
Owner is the
right of
party here.
enjoyment. I am enjoying.
Sir, owner is a party here. Landowner.
Owner has no objection. My lord,
Huh?
my lord asked them.
His
to submit
objection,
affidavit.
no objection doesn't matter.
Lordship,
It's good
question
not
is
for
that-
you, it's good
Lord-
for them. If
Lordship-
he has no objection.
Lordship, ask them to submit the affidavit. I'll
What
go to my-
affidavit?
Affidavit.
You file a appeal against this order,
No,
dismiss.
Lordship, similar what are already been disposed of by Sole Court, Lordship court in base. Lordships.
Is the law has been settled, all law has been laid down there?
Lordship direct, yes.
Is the law has been laid down in that order?
Directed to dispose the similar case, Lordship.
Huh?
Coordinate has disposed of similar cases
For what?
regarding assessment of Jirat Bill, Lordship.
That's why I'm asking whether the law has, any law has been laid down there?
Yes, on the basis of.
No, there.
Lordship, consider my representation, Lordship. Lordships, some instruction also required. In the meantime, Lordships, even in France, I also filed an IA also regarding not to demolish our house. Yesterday on call, Lordship.
We'll direct them to demolish immediately.
No.
Forthwith.
My lord. You
You file a IA, we'll direct them to demolish.
No, my lord, notice issued against this, Lordship.
Huh?
Against this not to demolish, notice issued this for our court, Lordship.
We'll direct them, bring that
sometime
list it
maybe-
and direct them to demolish.
I will take instruction on this.
You are a
Lordship,
lazy,
so that,
how
demolish,
you have-
so that they demolish on my lord kindly. Please bear my prayer, Lordship. Sometime maybe I will take instruction on this.
Although this court finds no merit in this writ petition,
Lordship, my lord,
comma, on the,
my lord, my prayer is that, Lordship. At least 1 week, Lordship. I will take instruction on that. So that they have demolished, some development has come, Lordship. 1 week, Lordship.
They
Monday.
are not the actual
1 week.
ownership and rightful owner for their payment was already processed, Lordship. So they are
That's
not
why the instruction is
they have
required, Lordship.
constructed
Some of the
construction,
owner
Lordship,
also.
after publication
you
of the three
think
notification.
over
Lordship.
10 days, after 10 days.
After 10 days. Take up, Lordship, after 10 days.
I'll record by prima facie view.
Lordship.
I'll record by prima facie view.
Lordship, only after 10 days, Lordship.
After arguing the matter at some length, Mr. F.U. Burbuya, learned counsel the petitioners, pressed for adjournment of the matter so as to so as to enable him to obtain instruction from the petitioner, as the petitioners herein are the lessee of the
Lessee plus owner.
land who
Both, Lordship.
claims to have
Lessee as well as owners.
Uh,
Some of the owners also. Lessee as
constructed
well as
some structure over the land of the lesser.
Lordship.
Hmm?
Like,
Praise the Lord. List after 10 days.
Lordship.
We'll give you a fixed date.
Lordship.
Lordship, that may be.
Yes, Lordship.
After 10 days, just say after 10 days. In the meantime, you bring on record, whatever.
Respondent of 5, I may pay.
Both in the meantime,
Commissioner.
Mr.
RK Taluk.
J. Henry, learned State Council, and Mr. R.K. Talukdar, learned counsel for
NHIDCL.
NSA may file their respective counter affidavits.
23-6.
Oblige.
Supplementary item 29, 30, 31, 32.
Correct. Supplementary.
Please, Lord. So in
Yes.
last occasion, Lord, they were directed to file affidavit. The pleadings have been completed, Lord. But I'm praying, Lord, this matter will be taken final disposals next week, Lord.
Why?
My lord, I have an IA application, but we are the employee of the Aswell Tea Garden. We retired way back in December 2021. Because of the stay order passed by this honorable court, my lord, we are not paid the amount at all. Now I will take your lordships to the order. Your lordship may kindly come to page 18, my lord. In my IA application 3704. Order dated 10/11/2023. At page 19.
See, this is how this is all are connected. This item 29 is by?
By us, Lord. Lord, may I indicate, Lord,
Yes.
what has happened, Lord? petitioner here is a company which owned 3 gardens,
Hmm.
but they had certain dues in respect of PF authorities as well as bank, my
So
lord.
that has been put on auction, sir.
Yes, and what has happened, my lord, in fact, the earlier bank had also challenged the auction made by the PF authorities, my lord. There was a writ petition
Hmm.
saying that, my lord, whoever has the first power of right, my lord, that
Hmm.
was an issue to be adjudicated upon. What has happened, they auctioned it, and my lord, they had appropriated the fund among themselves, withdrawing the earlier rate. We have come, my lord, what has happened, 3 gardens altogether have been auctioned. My lord, in respect of the first auction, my lord, the reserve price of the one garden was higher than their amount.
Hmm.
Now the cumulative 3 gardens they have subsequently added and the reserve price has been reduced. But they have violated the provision of the Income Tax Act. That we are making an allegations that the process.
Okay, then
due process-
item 30, 31, 32 is.
But that is a writ petition. They are seeking because the PF authority has realized the money. It's like a money decree seeking from your lordships that they will, that direction may be given to the PF authorities to clear the dues of the company, my lord. But basically, it's a money suit in the form of a writ petition. So far, my learned friends, please, there, not. He says that he is the retired employee. His dues are there, which they ought to pay, and because of the interim order, that payment has not been made. But my prayer for your lordship consideration would be, my lord, that your lordship may kindly take it up for final disposal next week, my lord. I have some difficulty today. And my lord, private respondent, Mr. Sahiwala.
Yes, I'm there.
No. Amit Sahiwala is there, my lord, in my case, who is representing the respondent, my lord.
This is the respondent number 5.
Yes.
My lord, what my application he has not.
My lord,
not
will see
written.
last order also, my lord, no order was passed in the IA. My lord, understanding was that this should be disposed of
IA is
altogether.
for vacating the interim order.
Yes.
My lord, this
Will
order.
dispose of the entire matter.
My lord.
My lord, if my learned friend will take earlier occasion, so many times he has taken adjournment. Because of that. it has been
We'll
delayed.
see, we'll admit this and list it for hearing,
My
on
lord.
hearing day.
My lord.
My lord, if it is.
That will be better.
Lord, can it be after 1 week, my lord?
After 1 week, maybe. We'll give you the fixed date.
Yes, yes.
After 1 week. Not 18, after 18.
Yes.
My lord.
On the pair,
No,
we'll
only
fix
thing, my
it.
lord,
23rd, will
before vacation, it will open.
23rd June.
Yes.
Oh.
Look, the other files had not come today. So it may also.
Okay.
Oh, files have not come.
Heard Mr. R. Dubey, learned counsel for the petitioners in WPC 6459 of 2023, comma, Mr. And Mr. S. Datta, learned senior counsel, assisted by Mr.
I am appearing for respondent 1.3.
Just wait. Somebody.
Assisted by K. Bora.
Yeah, Bora, learned counsel for respondent number
6, 7, and 8.
6, 7, and 8, and Mr.
J Bora for 1, 3, 1, 2, and 3.
J. Bora for respondent.
Malas, I am for number 5, Malas. AK Sahiwala.
In item 29.
Yes.
Malas.
30, 31, 32, I am for a petition.
Mr. J. N. Sahiwala, and also Mrs. J. N. Sahiwala, counsel for assisted by Mr.
HK Sharma.
HK Sharma, counsel of the petitioners in WPC 672-1487-1527. Next paragraph. As agreed to learn counsel for the parties that this matter be listed on 23rd. 23rd is Monday or what? Hearing day?
Tuesday, Malas.
Tuesday.
23rd.
The interim order needs to be continued.
Interim order passed earlier said continue. Till the next date.
Obliged.
All right, 25.
Subsequently, come to the order that is 28/1/26 passed by your lords. 28/1.
My lord. My lord, last occasion, my lord, learned field, my lord, that regarding my lord Shikari Bosu case, my lord.
Ah,
My lord, before going to the judgment, my lord, that my lord, proceed with the my lord facts, my lord. The petitioner is the my lord owner of a vehicle, my lord. That is
okay.
stolen.
Issue is, let us now go into all those all hog of the facts.
My lord,
All right.
my lord,
The FIR has been filed.
my
And the investigation has been culminated into final report.
final report,
That has been accepted.
my lord.
You have not challenged that. You have to challenge that.
My lord,
Not in a writ petition.
my lord, I have filed a protest petition, my lord.
Ha.
That
That will
has
be
been, my lord,
considered by them.
My lord, that has been rejected by order dated, my lord, Lordship may come to know, my lord. Page 43, my lord, may I read the order?
What is the remedy thereafter?
My lord, only thing, my lord,
Under the law, what is the remedy thereafter?
my lord.
Not the writ petition.
The remedy, my lord, either I can come, my lord, 482 or may, my lord.
Huh? This is 482 petition.
My lord, this is both, my lord, with read and my lord,
Huh?
226 and 482, my lord, right, 482, my lord.
Where it is?
What's that, my lord? Right with section 482, my lord, service.
482 would be a different one, not club with 226.
My lord, only one thing is remain, my lord, that I can file second, my lord, protest petition in court allow, except that my lord, court, my lord, has to give some relief to the petitioner also, because my lord,
We cannot. When you have
because I'm remediless, because
when the remedy is available somewhere else.
my lord, some judgment I have not brought today, my lord, that there is some judgment that
See, that way we have heard on
there is no bar, my lord, to enter.
Sir, we have heard on that day. That
I was not
they
present,
had
my
a
lord.
privacy view already recorded.
My lord, that in judgment also itself it is reflected, my lord. It is not absolute, my lord. Where my paragraph, my lord.
Why this has been listed for
My lord.
orders?
My lord, this what my learned friend, my lord, says this judgment, my lord, that paragraph 20, it is true that alternative remedy is not an absolute bar to a writ petition, but it is equally well settled that if there is any alternative remedy, the High Court should not ordinarily interfere.
You are saying that you don't have the remedy.
My lord.
How?
My lord. Because my lord, not able to see the my lord, the FR, my lord, FR report, my lord. Because I am the complainant. Then he is filing the FIR, my lord, accusing me, my lord. So if I file a complaint petition against whom I will file, my lord? Suppose if I file a complaint petition for all problem, what against whom?
See, your protest which has been rejected.
Rejected, my lord.
It's
Only
not
because
appellable,
of
it's not an appellable order or a revision order.
There was a revision under section 397. Because that the case is no more there. This is the final, either he can, my lord, 397 revision, my lord, or appeal, my lord.
So Lordship may,
So no 482, my lord.
Lordship may come to the my lord,
This is not finished.
the my lord, FR, my lord. I may add it, my lord. It is a description of the final report that on 24/9/2014, the complainant.
No, it's okay, sir.
My lord,
After the rejection of your protest petition or whatever, whether it is appellable or is a, can you not file a revision petition?
revision, my lord. Revision, my lord, because my lord, the order, my lord, maybe my lord.
See, Supreme Court has clearly said that that if the report has been accepted and no appeal or revision was filed against the order of this magistrate accepting this so and so, then matter ends there.
Oh, my lord, only thing is that my lord, when they have filed this, my lord, the final report by the IO, my lord, the court has not passed any order, my lord. Because on the assumption, my lord, I have filed a petition, my lord, protest petition.
That cannot,
That has been
that
rejected.
cannot be a ground for, the subject matter to be
No, but either,
agitated
either,
under the,
either,
in the
there is a
by way of writ petition, sir.
No, my lord, either judicial magistrate has to pass an effective order, either ejecting or accepting, my lord.
Sure, you go to the appropriate forum.
My lordship, if you permit me to file a second protest petition, then there is a remedy, my lord. That there is no bar or file a second, my protest petition also.
Heard
my lord.
Mr. M. Sarena, learned counsel for the petition, and also heard Mr.
R. Goswami, Lordship.
R. Goswami, learned counsel for the
Response number 4.
response number 4.
So PK does for
Big-
6.
6 to the and.
My lordship, my before passing, the order of the magistrate, my lordship, have a glance, my lord, please, my lord.
You either file an
No,
appeal,
because
appeal
they are
if
saying
it
that
is not
my
appellable
protest-
order, sir. If
my-
it is
my-
not appellable,
My protest petition.
if
will
it is not
format-
appellable, then you file a revision
No,
petition.
No, my lord, my prayer is that the order is my saying, so my lord, my protest petition is
This
not in format.
The order
So
may
if court
be,
permit me, my lord, second-
order may be illegal,
my lord,
purpose, whatever.
my lord, if court permit me, I can file another protest petition. That's my prayer, my lord.
Why read
It's
court,
permissible,
read
right?
court and why permission is
Be-
required?
Permission required because there is a
If
delay,
the
my
law
lord. They may
permits
not
you,
accept also.
why
The
the,
court may not accept
why-
also, my lord, due to delay
so
ground.
we cannot preempt.
Court, my lord, may not accept also due to delay ground.
If
my
they
lord.
don't accept, you file an appropriate application.
And that's why my lordship, the court is honorable court directs my.
See,
then I can file.
tomorrow you have not filed that.
I should not be remediless. That's my prayer, my.
There is no, this is enough remedy.
No remedy, my lord, because the
Am I
revision does not
remedy?
like, this is not a, my lord, this is an interlocutory order, my lord. How revision lie, my lord? That part I am not coming, my lord. This is an interlocutory order.
Who
If my
says,
lord-
who says no revision lies against the interlocutory? Where is the interlocutory order?
because my lord, if.
The acceptance and rejection of your protest petition is not an interlocutory order, sir.
No, my lord, I mean, my lord, the court itself neither rejected or accepted the my lord, final report.
You pursue that in that case.
But that is not
What is
reflected in the order. my
what is your prayer here?
prayer here might have quashed the whole this final report and my lord, the impugn order.
We
my lord.
cannot do that. We cannot do that unless the concerned jurisdictional criminal court pass an order.
No, my last thing, we have to see the judicial order passed by the last magistrate, my lord, whether it's an interlocutory order, my lord, it's a final order.
Hmm?
If it is interlocutory, revision does not lie, my lord. The final, you have to interpret, you saying the final.
The
order.
acceptance of the final report,
My lord.
is it an interlocutory?
My lord, there is no order that they have accepted the final.
It has been accepted and final, your protest petition has been rejected.
My lord, before accepting, I filed, my lord, coming to know, due to my lord, RTI, my lord. Then coming to, I filed a petition, my lord, before accepting, my lord. Then they, my lord, after my filing the petition, my lord, my prayer has been rejected only because of it's not in format. I may be allowed to file a format petition, my lord.
So
The
you,
protest
who
petition.
is stopping that?
No, my, there may be a delay ground, my lord. That's why court if condone the delay, my lord.
You withdraw and will give you liberty to file a thing because you rejection, ground of rejection not in a
No,
proper format.
That's my optional prayer, my lord. Courts allow me to file a protest petition.
So,
my
well, sitting at the writ courts, man, we have better things to do than all this kind of
Let me read it for
the
maybe
not
report, my lord.
the kind of issue raised unnecessary.
Then
See,
my
why
that come up for admission, my lord. I'll confess your lordship, my lord.
I have rendered, I have given my prime view already. It's a judicial order, already recorded.
My lord.
Just because that day you were not there. So today I heard you also.
My prayer is that I'll convince you, my lord, maybe on admission, my lord. This is order says, my lord.
On the prayer of Mr. M. Saran, learned counsel for the petition, list this matter for admission.
Yeah.
After 3 weeks. After 3 weeks.
I'll never.
Delegated 26, 27.
Please, my lord. My lord,
this matter, we were shopkeepers.
Hmm?
We were shopkeepers
Hmm.
in a Gau Panchayat compound. The Gau Panchayat compound, and because of widening of a road under the Assam Mala scheme, our shops had to be broken. Now, my lord, we had sought for some compensation. At that time, verbally they said that, okay, you break now, and then we're going to give you some Jirat compensation. Now, first of all, of course, we are not landowners. That we are not. And they have also, the district commissioner of Darang had filed a reply in which they have not denied that we did not have shops. They said that that was not on Patta land. And that is true.
That's a government land.
That was, yeah, that was a panchayat area, and we were not encroachers. We had our trade license, we had our.
What is the provision? Under what provision you are claiming? When you have constructed something
Yes,
on a government land,
Yes.
without there be
Yes, sir. My lord, that
without
I'm
any
coming.
valid permission
Yes,
or
yes.
authority,
Yes.
how can you be?
Yes. No, first of all, they are not saying that we were.
They are saying will
encroachers.
not do.
Yes,
Law will
Yes,
have to
yes.
regulate.
Yes. So if we go as per law also,
Hmm.
Lordship, now there is a concept of affected persons under the Right to Fair Compensation Act.
Hmm.
And that is the provision of that act has been taken.
Has it been acquired?
It has been taken for direct sale purchase under that, and the scheme.
Have you
and the scheme, Lordship,
sell purchase in respect of the land,
in
private land only,
private, yes,
not the government land?
not the government land.
No, this is
Of
a
course,
government land. You have constructed your structure on the government land.
Now, Lordship, one thing. Now, the notification, the Gazette notification, which was annexed by the the district commissioner, it is in page 114 of their affidavit. Promotion.
114.
14.
Saying what?
And 115. Now, 115, they have taken up a specific section that for expeditious acquisition, 115 in paragraph 3, if Lordship says.
Assam Mala bring.
Yes, the Assam Mala being a flagship program.
Also, the expeditious acquisition of land for speedy
implementation of the
section
section 46(1) has been considered for direct purchase.
Yes.
Now, if we see section 41, sorry, section 46. Now, this talks about a rehabilitation and resettlement package. And so far as affected families, the definition says that if somebody has been working, they may not be landowner. If somebody, their primary source of livelihood was there for the last 3 years, then they're affected persons. And also the schedule of this act talks about a one-time grant for artisan, small traders, and certain others. And the amount is not much. It has to be a minimum of 25,000 only. That is the minimum that is provided. It's in Schedule 2. And Schedule 2 of this act does not talk about the ownership is not at all an issue here. The only thing is if livelihood is affected, if that was the primary, that of course they have to see, they have to verify. We can file our representations and all, and that's already filed. So there is a provision under this. So this small window exists within the law also, wherein somebody not even landowner.
Let us see. Right to fair compensation. (2013). I can get the other one. I think one is. Section?
Now, section 46 is the one which they mentioned.
46. Provisions relating to rehabilitation is certain to apply in case of certain provisions other than this special person.
So if this is
purchasing a land through private negotiations for an area equal to more than such thing.
And this can be read with lordship, schedule 2 of this act.
This is purchasing of land through private negotiation.
Yes. So what I was trying to highlight to your lordship is that even in this,
For which the payment of rehabilitation under the Act is required, he shall file an application with the district collector. This is a provision applied to the person other than the specified person.
now lordship, that is.
They proposes to purchase the land.
Yes, yes. So that is also a confusing thing, because here Assam Mala government is acquiring, but they say that they are basing their acquisition on 46. But if we see that specified person, this is for something where land is acquired not by specified person. Specified person is the government. So this is a provision which is not. So in that way, even this notification is wrong, incorrect.
Okay, notification may be wrong, but then what is your right? That is the issue.
No, my right, my lord.
Where is it? Where is Schedule 2?
Schedule 2, lordship, at the end of this act,
What does it say?
now, lordship, may kindly, in my book, it is page 55.
Ah,
Now,
element of rehabilitation resettlement.
yes, I am on point 8, one-time grant.
Artisan, small traders, and certain others. Each affected family of an artisan, small trader, unemployed person, or an affected which owned non-agricultural land or commercial industries or industries. No, this is on an affected which own non-agricultural land or commercial industrial insurance in affected area which been voluntarily displaced from the affected area due to land acquisition get one time. This is not a land acquisition. It's a government land. So there's no question of acquisition of that land.
Land cannot be, of course, government cannot acquire its own land.
Yes, therefore,
it's already their land.
Therefore, what is the right? This is
So,
suppose in case of the land,
Yes.
if in case of the this thing, what do you call artisan, still certain other people.
Yes.
If you are on that land,
Yes.
and when that land is acquired, then only certain compensation is due. Minimum compensation has to be given to you, to that person who had occupied to that land, which is a subject matter of acquisition. It's a government land. There is no question of acquisition on the land.
Actually, under the affected family, lordship, if under 2 subsection C, within affected family, the act is made in such a way.
What is this? Affected family?
It is in definitions, section 3. Section 3, then within that, subsection C.
Family whose land or other immovable property has been acquired.
That is 1.
Which one you are saying?
I can say about 2.
Ah.
Clause 2.
Family which doesn't own any land, but a member of members of his family may be agricultural labor, tenants including any form of tenants or holding of usufruct rights, share proper searches of who may be working in the affected area prior to the acquisition of land, whose primary. Yes, again, this is about the acquisition only.
Lordship, this says
You
that.
may be there when the land is acquired, then only.
Yes.
When
But
there is
Lordship,
no
here it says
acquisition of
who-
the land,
Yes. Who
then
may not own any land is written.
you have to read entire whole,
Yes.
not bits and bits.
So that's my submission. Really, I thought.
Very simple.
Yes.
Huh? Section 646(1).
46(1).
Read with section 3,
3C
3C
Roman 2.
2 and schedule 1, schedule 2,
Schedule 2. Yes, schedule 2, point 8.
8. Okay, disposed of. Anything?
Not acquisition under the 13 Act, 2013 Act.
But
Is
you have
authorized
issued a
as-
notification, direct purchase,
Direct
under
purchase.
section 46.
So unless
That
they are-
was not, it would not have been applied.
No.
But you have issued notification, the direct purchase negotiation.
direct purchase, there is a
Because you are not a specified, you are the specified person. Government is the specified person.
Yes, yes.
This is section 46 will apply in case of the person other than the specified. If there is a negotiation for purchase, I mean, purchase through negotiation.
there is
Since you are a
complete scheme.
specified, how can you apply that?
There's a complete scheme, my lord, how to do the negotiation. Owners will be called, objection will be called.
But why under section, how can you apply section 46? Once you apply section 46, other, this thing will also follows. We'll see. You have filed a representation.
We have filed it.
If we find that there's something, any scope, you reconsider it in accordance with law.
Yes.
All right.
Much of
Both are same.
both are
Same,
Yes.
same area,
Same area.
same area.
Yes.
Why two different petition?
Some are in the panchayat area and some are in the market area. Only this is the difference. The first petition.
But the land is
Land in both
admittedly
case-
government land.
in both cases same.
It's not a private land.
No, in the first case, they are within the panchayat compound, Gau panchayat compound. In the other case, it is within the government market.
Where you have been allowed to, you do have a trade license.
We have trade license.
You had a trade
We were
license.
allowed to operate.
Huh?
We were allowed to operate
With trade
with
license.
trade license.
Yes. Yes.
In fact, lots of this issue has already been decided.
Huh.
They are enforcers, lots of, basically, they
Ah.
are enforcers of government land. And so far as this direct purchase scheme is concerned, this is a scheme through an agreement to be arrived at between the government and the landowner. He is not the landowner, he is not the pattada.
No, no, if he, had he been a
not
landowner,
really-
method would have been different.
Yes.
There's no question of, they would not have come here also.
Yes,
They have been already paid and done everything.
yes.
Problem is that they are the traders, small businessmen, petty businessmen, and they have been allowed with the.
In that situation, yes, I understood. what
So
was-
that's why I'm just, I'll examine these provisions.
Yeah, in that situation, Lordship will allow me to place 2-3 judgments. Lordship will keep this as CAB. In the meantime, Lordship I place 2-3 judgments. Because this is.
Saying what? Applicability of this section 46.
Not saying applicable. Lordship, enforcer are not entitled to any compensation.
And it's not a question of encouragement. They are traders.
Compensation,
They are the shopkeepers.
yeah.
Maybe a government land.
Shopkeepers in the government.
They have the trade license.
Lordship will understand, Lordship will appreciate Lordship.
Where is the any record to show that they are encroachers?
If it is government, then definitely they are enforcers.
No.
Where is the? no-
See, traders, if you issue a license,
Yes.
certain specific area, they can do
The
that.
license will not justify his title, Lordship. The
It's not a
is
title.
Title we don't.
I will justify.
They are not asking, they are not saying that they legally, they are the owner of the land.
Yes,
They are saying that we are
Document-
traders with valid trade license, we have been allowed to run shops. And on the government land.
Today, at this moment, Lordship, it may not be possible for me, Lordship, but I am aware of judgments, Lordship. which
You
is
bring,
already
you keep
itself.
it.
Lordship,
I am not keeping it CAB. I'll pass the order today.
Today itself, Lord.
You
Then-
find out.
Then on tomorrow, day after tomorrow, my.
Heard, Mr.
MK Chaudhary.
Learned Council for the M.H. Chaudhary,
No, MK Lordship.
M.K. Chaudhary, Learned Council for the petitioners. And also heard Mr. P. Nayak, Learned Additional Advocate General,
Yes, I am appearing for PWD, Lordship.
as well as Mr. Vijay Talukdar, Learned State Council for the respondents. All. Three, four. You are for respond number?
Respondent PWD, Lordship. I am not.
All are represented. I'll pass the order. You submit by evening, we may, by afternoon.
Tomorrow I'll check. Lordship,
Tomorrow to.
another matter is going on, Lordship. Just because that told. Actually, Lordship is.
No,
not so
enforcer
responsible.
doesn't have the, by there's no, there's a settled position.
No, this issue has been.
This has to be decided in context of the right to fair compensation. Because you have invoked section 46, right?
No.
Which I find
Section 46.
it has been invoked.
No, not invoked.
It has been invoked.
Lordship will see the notification. That section 46 will be invoked only when there is no agreement between the parties, state and the, I mean, the landowner. In that situation, the Land Acquisition Act will come into effect, or the Fair Compensation Act. In other situations, no.
So how, under how you have paid the compensation to the private landowners?
By, I mean, this notification itself is there.
Direct purchase,
Direct purchase. So in negotiation between the government and the landowner.
not under any right
Not
to
under
fair
any-
compensation.
For that purpose only this notification was issued. This scheme was initiated. And there is a specific provision in that scheme, Lordship. In case there is no agreement between the parties, only in acquisition, provisions of Land Acquisition Act.
Acquisition through direct purchase.
No, if direct purchase fails, in that situation, Land Acquisition Act will come into effect. That is the provision of this notification.
And there was a direct purchase.
Yes.
Therefore, it applies.
No, it not, Lordship, in case no agreement.
No, in this case, we have acquired the land through direct purchase
Yes,
by paying the amount,
paying the negotiated amount.
negotiated amount,
Yes.
not under any
Not
acquisition
under
law.
any other law.
No,
Other
any-
laws are law, yes,
Why this notification in that case?
for that purpose only, Lordship. In case of Assam Mala, if Lordship looks at the preamble of that notification, Lordship, it is quite clear, just to, I mean, cut away the unnecessary delay, Lordship.
No, that's what I'm saying. Suppose you in the Assam Mala, you have acquired the land through direct purchase.
Yes.
You have not applied the right to fair compensation. Then why you say that in para 115, page 115, that notification? That section 46 will apply, is not it?
Section 46 will apply only when there is no negotiation. In negotiation, it fails, Lordship. In that situation, that other act will come into effect. Otherwise, no, Lordship. That is why I'm submitting.
So what judgment you would like to place?
Lordship, this situation has already been decided, whether enforcers or government lands are entitled to compensation or not.
No, that is the larger issue. There's something different.
That is the issue. Lordship.
The traders,
Lordship,
the traders under Assam Mala.
No, they are not traders under Assam Mala, Lordship. They are illegal occupiers of government land.
No, why you have said so?
They are saying that they are occupying government land.
Not occupying. They have allowed to settle there. I mean, to run their business shops there
Lordship,
with a trade license.
Lordship, trade license, that is what I'm submitting, Lordship. They are, basically, they are illegal.
They are
occupiers.
not asking for land compensation.
Yes.
Jirat kind of compensation, they are structures in which on the basis of the trade license, they have allowed to run the shops there, panchayat area and marketplaces.
Be it government land or be it patta land, Lordship. nowhere lordship, a trade license will give them a right. That is also law.
See,
The
when,
trade license would not,
My lord, let them see case to case basis.
Legalize their
We-
occupation. That
We
is
will
what
give
I'm
our application if necessary case to case basis. The local authorities actually know what is the genuine thing and what is not, and whoever is genuine, they may give this only 20.
that extent, lordship, I have no objection.
Yeah, only that much only.
Without passing any observation, lordship, if they simply file one representation,
Case to
and
case
if
basis,
the
they will-
authority decides, then I have no objection.
That much only.
To that
was-
extent, lordship, I
Huh?
have no objection.
So lordship, now what? The
no,
land-
see, we'll have to direct them to consider your case
Yes.
on the basis, when we
Let
come
it
to
be
a
on case to
finding,
case
when we
basis.
come to a
Yes.
conclusion, at least you have the right.
Yes.
Unless if you, we don't, cannot first issue a simple, futile writ.
No,
If
lordship,
this is your case, we'll dispose it in a 2-page order,
Yes, to that extent, lordship.
2-page order.
Authority will.
You want that?
the lordship can do that if they are agreeing to it, then it's, then
In that situation, authority will decide. That is my suggestion.
So we'll not examine whether you have a right under the Fair Compensation Act or not.
no, lordship, that much can be done.
See, we'll have to establish that. That's why he's objecting. This is not under the acquisition has not been, and the payment has been under 2013 Act.
Yes. No,
It's a direct purchase negotiation, through negotiation, direct purchase.
yes,
No, the provision of this act has been applied.
yes. So
Therefore,
lordship-
how can we,
No, actually, lordship can make a decision
Lordship, I am
on
showing on specific paragraph, lordship, if lordship comes to page 117.
we'll continue at 2.
Lordship to,
You decide. If you want a simple direction, you have filed a representation for
Yes.
disposal, we'll direct
Yes,
2-page
authority will
orders we
decide.
can.
in that line, if lordship.
Otherwise, you will have to establish, determine whether you can be, you have any right under the 2013 Act. When it has not been applied in a particular thing, when you have not challenging that, not application of, not applying the 2013 Act, where you have not challenged that, we cannot examine also. We'll see, think about it,
Yes.
2 o'clock.
Item number 26, 27, continue.
Where is Mr. Nayak?
He's on dates in some other court, there's a fixed matter. Lordship, may kindly come to page 117,
117.
it's 4.17, step number 17. In the event of any owner refusing to sell the land or any other owners has objected or not interested with the direct purchase through.
Where it is? 117.
417,
Ah.
that is step number 17. In the event of any owner refusing to sell the land or any of the owners have objected or not interested with the direct purchase through negotiation, the respective land may be acquired through acquisition process of so and so, as of the 13th Act, my lord. This comes only in case of refusal by the owner, because this is direct person. And amount of compensation is also more when it is done by direct persons. 25% more, your lordship will find. 25% of the same. So under this scheme, my lord, there is no provision for Jiran. And our affidavit is very specific that under this scheme,
encroachers of government land, there is no provision for any compensation. Paragraph 8 of our
Page,
page 107. Also in paragraph 6. it Starts from paragraph 6. That is 106, page 106. So the opponent begs to state that compensation was paid to the Patta landholders. Since shopkeepers' buildings of the petitioners are situated on a government land, there is no such provision has been incorporated in the Gazette notification that scheme, my lord, regarding payment of compensation for structure in government land. As it is land acquisition through direct purchase by way of negotiation. Then paragraph 8. The same thing will be repeated. The opponent begs to state that the compensation was paid only to the Patta landholder, since Pakka shops, buildings of the petitioners are situated in government land, and there is no such provision has been incorporated in the Gazette notification dated so and so regarding payment of compensations for structure in government land. It is land acquisition through direct purchase by way of negotiated settlement or improvement and upgradation of state highways and major district roads.
So according to you, according to the state, since their shops are
On the government.
on the government land,
Therefore, they are not entitled.
there is no scheme only for direct purchase.
Direct.
In the event only, if it is not agreeable,
By
then
the
only
owners,
land,
by the owners
by the
of-
owners of the land.
Then
only.
we'll get back to the care compensation.
How you are allowed to, how you are allowed to
And-
construct
and-
this
and I'm
Pakka
coming to
shops?
it.
Ah.
And if they say that they are on permissive portion of some panchayat or some owners, they will step into their shoes as they see, not more than that.
Huh?
Some owners' land, if they are occupying, then they will be considered as a lessee. So the liability will be on the owners, not us.
Oh, Lordship, first of all, that encroacher issue in Assam we are having, but this is separate from that, number one. Because here we were having our shops within the panchayat compound. And when the land was acquired, we had welcomed that. In our representation also, the first paragraph says that we welcome this widening of the.
Where is your representation?
It's on page 100 of our
100.
representation. We have always welcomed this widening.
No, you cannot also object also, right?
Yes, we cannot object also, that is. I can make a categorical submission that if any one of us is an encroacher, let us not be given compensation. That part can also be observed. But the local authority, who are the panchayat authority or the deputy commissioner, they had inspected prior to even breaking the shops and all. They will see whether we are encroacher or we are permissive occupier, of course, because this 2013 Act says landowners or otherwise. Or otherwise, my lord, it will definitely mean government land, because any land which is not a patta land, ultimately it is a government land.
But if I'm placing just one judgment, Lordship, I will furnish a proper copy, Lordship. At this moment, I have taken print out from case 9, Lordship. It's Mohammed Khorses Ali versus State of Assam, Lordship, which is a 2009 judgment. Herein also, Lordship, if Lordship may come to paragraph 7, Lordship.
They were occupying government land, lordship. They were even paying municipal taxes also. If lordship comes to paragraph 7, it is in the aforesaid backdrop. This writ petition has been filed with the prayer for declaring the eviction of the petitioner as illegal and to pay compensation to them. If lordship comes to paragraph 22 and 23. Paragraph 22.
22.
As noticed above, the land in question is a roadside land adjacent to National Highway. The petitioner, after purchasing the possessory right, made unauthorized construction over there and rented out such construction to others. The land being a government land, the government is within its competence and jurisdiction to settle the same with the ASTC for a public purpose. Such public purpose will naturally outweigh any other right. If the petitioner has made some construction over the government land for the rent purpose, same was at his own risk and cost, such unauthorized construction cannot vest him with any kind of right so as to contend that his eviction from the land and demolition of the construction were illegal. The petitioner then paragraph 23 lordship. Ultimately, this petition was dismissed, lordship. Paragraph 24. Basically, this is the law, lordship. I can play several other judgments also, lordship, on this topic. I'm aware of those as well. But because of time, lordship, at this moment, cannot be possible.
Lordship, there is one more aspect in this matter. In our reply to their affidavit, we have also brought in on the same road, there is another market ahead. And there, even on government land, I mean, the parity aspect I'm bringing, if not on any other law, at least on parity. Our lordship may see some notices in our reply. In our reply affidavit, wherein we have we have annexed some notices given to some shopkeepers on a market which is just on the same road after this was also affected by because of this widening. Here it's written that the patta was also sarkari. They're also sarkari, but some compensation was given. So compensation was given in that.
We don't know how they have given, why they have been.
So that is why, my lord, that I'm not saying state may do something legal, illegal, but I'm not asking that from the court, but only on the parity aspect I'm saying.
No. Suppose if somebody is not entitled, they have been paid. You
Yes.
cannot
No, that of
claim
course.
parity on that. Whatever they have given legal, illegal, it has to be legally. be
Court
given.
cannot do illegal. That's there.
I think since the project, on the basis of the project, there is a scheme
Yes.
how to go with it. Procedure has been laid down. You are admitting that it's a government land
Yes.
and you have accepted it has been demolished, road has been constructed.
Yes. Oh, my lord, then may I pray only?
See, so far as 2013 Act is concerned,
Yes.
affected person, specific person, interested person, in case of acquisition only. This is not a case of acquisition, I mean, simpliciter under any law. It was a negotiation, direct purchase. If the landowners or pattadars is not agreeable, then only that will apply proper. It's not your case also. You are not claiming any land right over the land. Simply you have constructed a pakka shops and you are running a business there and you have agreed and got it demolished. You could have agitated at that point of time so that state can, I mean,
Locally, what
look for
happens is
some
that-
scheme
Yes.
that may not be entitled, but On lump sum, you could
That
have.
lump sum, something like that, they had.
That
also
you
messed
could
up
have done.
formally.
Now it's over. What can we do now?
Now, Lordship, I am only praying because there is some right under the act which they are saying under.
No, there cannot be right under the act. It
No,
is
if there is any statutory right, then.
if it is acquisition of land, it's not an acquisition of land in fact. There's no acquisition of the land on which you have constructed a structure, right? It has not been acquired. It's a government land, no question of acquisition.
Now, most respectfully, Lordship, when the act says that there is, because the judgment which was provided was of 2009, that is before this act. Actually, only after this act came, there was some.
No, under the act you cannot. At best, we can direct them to consider your presentation in accordance with the law. Is that it?
That much, Lordship.
In accordance with law, that's
Yes,
all,
Lordship.
nothing else.
If locally
that
there
it?
is something, then.
What I'm submitting, Lordship, one line observation from your Lordship, although there appears to be no right in favor of the petition. Authority may consider it.
No, when they have no right, how can we
Under the
direct them
statute
to
or under the
consider?
scheme, they are having no right. That much is clear, Lord.
No,
That is the judgment also.
Okay, we'll dispose of.
Yes.
Will writ petition will be not allowed because your prayer is that as per the 2013 Act cannot be made applicable. Therefore, I'm not convinced. Basically, no relief. However, considering the assurance given by the Chief Minister of Assam, will direct the authority to consider your representation. That's all. In accordance with law. That's all.
Otherwise, Lordship, it will.
Not under the act, will not. You want me to record that?
Lordship, I do not want something which will be recorded, which will have an adverse impact on the.
Obviously, because you don't have a right.
Lordship, please, I will request not to exactly write that thing. Let it be open. And if there is anything locally, my petitioners will approach them.
No, I'll decide. In fact, your relief cannot be granted, but only we say, however, the representation may be considered and disposed in accordance with law. All right.
All right. Lordship. No, even your Lordship is not granting him any liberty to file representation. If any representation is filed by the petitioner.
They have already annexed it.
That will be decided. Consider. Obliged, Lord.
Dispose of. Heard, Mr.
MK Chaudhary.
MK Chaudhary, learned counsel for the petitioner. I think we have recorded, not now.
Already recorded.
You are there? P9, learned. Additional Advocate General.
Yes, additional AG, I am appearing for 1 and 5.
Respondent 1 and 5, and Mr. B. Taluk, the learned State Counsel for respondent 1, 2, 3, and 4.
2, 3, and
2, 3, and 4. We'll dispose it.
Lord, I'm appearing for Cooperation Department. My signature is on legs in Court 1.
Huh?
It's on legs on Court 1, my Lord.
What is the matter about?
I'm signed.
Matter is regarding, my Lord, challenge of a election of a cooperative society, my Lord. The registrar of the cooperative society has dismissed the representation filed as per election rule, cooperative election rule, my Lord. And again, this dismissal, the petitioner has approached this honorable court, my Lord.
My Lord, in this case, record is necessary, my Lord, as to how the registrar has considered the appeal, my Lord. And they have the alternative ability under section 111(3), my Lord, to file an appeal before the, my Lord.
Appeal has been filed.
My Lord.
Appeal was filed.
Appeal was filed before the registrar, my Lord.
Register. Then another appeal is, my Lord.
What is that?
113.
Which rule?
Assam Cooperative Society is there.
Act. Which book?
3.
Section 1112. Assam Cooperative Society, 7.
Where's the book? Which one?
This one.
Rule 11 subgroup 3 provides that if there is any question of law, my lord. But this petition is filed on the ground that the relevant documents is not considered by the registrar, my lord. Rule 11, section 11, sub rule 3. 111, subsection 3.
And they themselves participated in the election, confirming the validity of the my lord voter list. And now they are, after losing the election, they are reporting, challenging the same election. This is also not the case of the petitioner, that the person who died, they have voted by him.
Lie to the register from the decision made under the set of rules framed thereunder by a government officer.
Question number and provide such appeal. This is
Except on question of law. Will appeal lie to the government, my lord, except no appeal shall lie to the state government against the order of registrar except on a question of law. But here the petitioner's case is that in the election, there was a marked copy. The person who have cast their vote, the electoral roll is marked or attendance register is marked. In this case, there is severe anomalies of casting votes by the dead voters, by the invalid voters. I have mentioned in my lord writ petition, and also my lord, the copy of the this marked attendance sheet register was provided, my lord, as per direction of the registrar to the petitioners.
There's no question of law.
my lord, what happened in my lord?
Yes, who is for the respondent?
SK Taluk.
Register. Who has passed the order?
Register.
Register. Where is SK Taluga?
That is on election code 1.
So what to do? He's the main person.
Lords may fix another date. my lord.
Heard MJ Kadir, learned counsel for the petitioner. And also heard Mr.
Yes, SK Taluk.
No, you're wait.
I am for by the respondent number 10 should be.
Also heard, both the right. And Mr. So-and-so. Next, it is submitted by Mr.
K.S. Sodial.
K.S. Sodial, learned counsel, appearing on behalf of Mr. S.K. Thalukdar, learned standing counsel, Cooperation Department. That Mr. Thalukdar, learned standing counsel, is on the legs in some other court. This will praise for listing of the matter after 2 weeks. Praise the Lord. List the matter after 2 weeks. On the next day, the learned standing counsel to produce the records. 2 weeks.
My lord, the record maybe include, my lord, the marked copy of the attendance, my lord. That is required, my lord.
Record means record. Return the book. This one. I think this one.
My lord, a date may be fixed, my lord. Otherwise, it is very difficult for my lord listing the matters. A fixed date may be given, my kind.
In that case, after in the month of July, in the month of July.
Oblate. Well, issue here is very short issue. The petitioner company was engaged in construction on highway. And they used certain minor minerals. And now, my lords, now we are insisting that you pay the royalty whatsoever it is. And in that case, it's covered, my lords, because we can always insist on the royalty that to the source from which you extracted a minor mineral. Was it tax paid or not? FRCC, my lord, Forest Royalty Clearance Certificate. If they can produce that, well, nothing remains. It is simple.
My lord, this NHIDCL, my lord, they have issued that work, my lord, to us regarding a construction of a road, my lord.
What you are saying?
My lord,
What you have said?
we have said that they are a company engaged by NHIDCL to construct a road, more particularly Trechpur stretch, my lord. My lord, they have used certain minor minerals, sand and earth.
Yes, yes.
So, my lords, the issue controversy is, my lord, we are seeking some royalty from them. That's this amount of royalty against the minerals used, you pay to us. But they are disputing this thing, and my lord, but there's a covered judgment of our honorable court, my lords, which says we can insist on the royalty that insist on the there's a certificate called Forest Royalty Clearance Certificate. If they can show us that the source from there they extracted the minerals used in their construction is from a legal source, tax paid, royalty paid, they don't have to pay. They just have to come and show the source that they have paid the source, legal royalty, whatever is applicable, and that settles everything, my lord.
So you don't have that, sir.
My lord, I said, bless my lord, materials, my lord.
No. If that is the only issue,
No, that is not the issue.
if you have that certificate, so and finish.
We have,
You will
my
not
lord,
be charged.
those which are required, we have produced, my lord. I shall place, my lord, there. Here, the work was issued, my lord, in 2017. Then it was foreclosed, my lord, with effect from 1921. My lord, you have just lordship, note, my lord, that work was issued to us on 12/4/2017. And it was foreclosed in from 1921. Now, my lord, here, if the lordship will see,
Why three writ petitions?
who are virtually in one matter, they have issued a demand of rupees about 3 crore. We approached this honorable court. This honorable court, my lord, passed an interim order. Thereafter, they issued another order, my lord. So, two are interconnected. The second one is in the respect of different road, my lord.
Different road.
I shall place them.
33 and 34.
Yes, 33, 34, my lord, same.
33 and 34 same.
My lord, yes. My lord, 33, 34, my lord, this 34, my lord, that
Same construction road.
So 33 will cover.
First, you have when the notice was challenged.
Yes.
Then there was an interim order.
Interim order, then they issued another press interim order, my
So
lord.
that's why 34.
Yes.
And 35 is?
35 is separate, my lord.
Same issue.
No, same issue, but
Construction, different project. Okay.
So I'm placing my lord 33 now. Sir, I think it will go 5631, 563.
Why it is so voluminous?
Voluminous, my lord, documents are there, necessary, my lord, various necessaries are there.
They have annexed the whole project documents.
Let us see the impugn.
Yes.
30th
My lord,
2022. Term and emergency. Forest road. Where it is?
I'm coming.
31/12/2022.
Yes. 31/12/22, my lord, that is at page 140.
But prior to that, my lord, कौन सा आती है? My lord, may I first see? My lord, Annexure 7, that is issued by BIO. They verified all the documents submitted by us at page 122. 122. My lord, 122, you also got it, my lord? Is Annexure 7. This was issued by my lord BIO, my lord. Bureau of Investigation. With reference to subjects cited in this regard, a letter issued to Deputy Manager so and so. As per information documents submitted by the Deputy General Manager, the following calculation is made. My lord, your lordship find earth, my lord, so balance quantity is 681. Force aggregate so and so nil. Sand so and so nil. Then from the above, it reveals that construction company Simplex Infrastructure Limited so and so, below mentioned quantity so and so. Now, my lord, they calculated and they have issued it. Thereafter, my lord, notice is issued. Then, my lord, Annexure 13, my lord.
Submit the proof of the.
13 is important, my lord. Now, Annexure 13, I'm just giving you, my lord, my lord. Now, after verification, at page 133, my lord. That is the last demand by BIO. Page 130. They have verified all the documents. Page 133.
Yes.
My lord, you'll also find, my lord, earth total quantity utilized 751, 432. My lord, they found that these documents are there because we have submitted the documents, my lord. So far, balance quantity remains for document submitted 3,18,553 square. This is cubic meter. Then sand is 840,462. Now, my lord, they have calculated. Next page, the total calculation they have come 3 crore and odd, my lord. Here, what happened, my lord? There is a circular of the central government, my lord. Circular of the central government that you should utilize the earth and sand in such a manner. Well, I shall place that, my lord. That is very important, my lord. That my lord, at page 138. No, I'm sorry, not there. I thought. Page 119, my lord. The purpose of my road construction, my lord, central government has issued a circular, my lord. You also got it, my lord. Ministry of Road and Transport Highways, Government of India, is implementing the development program of national highway network across the country, which inter alia involves a considerable amount of earth work. Naturally, there is an ongoing need of earth for the embankment of various NH projects. The contractors, concessioners meet this requirement through buying the earth from farmers or producing the same through mining of minor minerals as per the provisions of the concerned state government. On the other hand, many parts of the country are facing several drought conditions, and one of the possible long-term solution is water conservation, discharging through creation, revival of water bodies, such as water tanks, ponds, check dams, farm ponds in rural areas, it has been observed that there is no good scope of synchronizing these two activities. It is being considered as to whether the process of procuring large quantity of earth can be harmonized with the ancillary activity of maximizing outcomes. Water consumption recharging can thus be very easily synchronized with the digging of existing or new water bodies from the procuring earth. This matter has been examined in the ministry and it has been decided to link the requirement of soil for the construction works of national highways with the digging, desiltation, ponds, construction of check dams, ponds in drought areas, as well as other areas of the country. Following steps be taken in this behalf. The agency responsible for construction of the national highways, state PWD, so and so, will advise that the contractors, construction agencies, through their field officers to approach the concerned district collectors, sub collections, water conservation departments to obtain a list of such villagers where desalination, revival of existing ponds, water bodies, digging areas, water bodies are there. So the informed district collector and water conservation departments should only provide the details of the identified sites so and so to the contractors, construction agencies, NHSL, and also facilitate the requisite coordination arrangement with respective panchayats so and so. Subject to earth silt being found suitable for use in road embankments, the construction agencies should excavate the earth as per project requirement from such identified water bodies at no cost to village panchayats, rural development departments, and water conservation departments, and transport the same in their project sites for use in the embankment. Similarly, panchayats and water conservation departments of the states should not charge any amount from the construction agencies for the earth excavated. So and so, the contractual concessionaire is responsible to complete the conservation work and transportation of so and so. Well, this is the later issue. Now here what happened, my lord? I said submit, my lord, that we have.
Why you are referring for this?
We have applied, my lord, that we can take the earth, my lord, for the purpose of construction of roads. That is why ministry has given, my lord. And here, your losses may come to paragraph 23, my lord. At page 35.
Page 33.
35. The petitioner states that out of the earth material about 20 cubic meter, utilized by the petitioner, 4,32,000 cubic meter of earth material procured by the petitioner after making payment of royalty, and accordingly forest permits were issued against such amount of earth materials, whereas 2,43,000 cubic meter earth material were used for construction of guide bound formation. With the reused soil, my lord, this is important, my lord. They have to excavate, and that excavation, that soil is to use, my lord, there for guide bound. Forest soil extracted from the same site where forest royalty is not applicable, and 20,000 cubic earth materials were procured from the structure excavation of the same site itself where no forest royalty is expected. Regarding 439 cubic earth materials, those were extracted from the river Jiavaroli for desalination at no cost to the village panchayat and rural development department, water conservation department, and thus transported free of cost to the project site, the petitioner, for use in the embankment, in which the other way helped the irrigation department for saving desiltation work, which was in conformity with the Government of India Ministry of Circular so and so. Therefore, whenever it was required to pay the royalty in terms of Assam Minor Mineral Concession Rule, the petitioner paid the same. Accordingly, procure the earth material after having requisite forest permit issued by the competent authority, and there was no outstanding amount of any forest royalty to be paid by the petitioner in respect of earth material used by the petitioner in project site. All these facts would not be placed by respondent number 4 as no notice was served on the petitioner, nor any opportunity for hearing was provided petitioner before issuing the communication to well, now your losses has found, my lord, that the Government of India is here, and then, my lord, we have also of saying, my lord.
Government of India is to
Yes. Exactly, my lord. That's
stop the.
this is regarding areas which are drought affected.
My lord, that we have procured some.
And even then also it doesn't indicate that when the earth is used
Yes.
for construction, the
Yes.
royalty will not be applied. It's not that.
My lord, and this is.
It is in a drought area
Yes.
to restore and not to damage this thing. Therefore, it was permitted to use for construction.
Yes.
But it doesn't indicate that the company or whoever using that for the construction will not and will not be
My lord,
required to pay the royalty.
my lord, from the same site, my lord, we have, because for the construction of the road, earth is to be excavated and that same is used there. I shall place, my lord, the judgment of the Supreme Court and the High Court also, my lord, in this regard. And further, my lord, this is not an unauthorized, my lord, act. My lord, what I am submitting, that if your.
No, sir, it's not, it may be authorized, but authorized with certain restriction, I mean, to payment of royalty and all.
My lord, here.
It is admitted that you have used the earth, you have used the sand, is not it?
But not commercially, my lord, virtually, we are using the same in the same road, my lord.
How can it be?
Because we have to excavate the earth, my lord, because from the groundwork, we have to do it. It must be some boulders have to be placed and other things are replaced. And that earth is used there. My lord. That is what I am submitting. And now here what happened, my lord, that the authorities, my lord, they impose not only, my lord, the royalty, but price of the materials, penalty, everything, my lord. That is how, where from, my lord? It is not come under illegal extraction, my lord. Not an illegal extraction.
Royalty is under root provision.
My lord, yes, your lawsuit, see, my lord, that page 36, we have quoted 64. Rule 64, my lord.
Minor concession rules.
Yes, Assam Minor Consent Law. Any act of illegal or unauthorized mining shall be liable to following. For first time violation, said mineral shall liable to seize along with the impounding of tools so and so, which may be released on relation of the payment of price of the material and the applicable royalties so and so. For second violation, the mineral shall be liable to be seized, impounding tools, equipment so and so, for 7 days, which may be released on so and so, payment of price and mineral applicable so and so. Where the person is found to be indulging offences for the third time or more, the offer concerned shall register a FIR so and so. These are
Yes, my lord, under that schedule, that rules, my lord, there is a chart against what material, what royalty you have to pay. And another, that very rules, there is a rule 5, that any agency which is into the government works have to obtain a permit. And there are also some forest regulations, my lords, of 1891. There is also a chart that against this specific cubic meter you have to get. And interestingly, this thing, my lord, that para 36, my London seniors read, Lordship will find that calculation is there, that I have out of this quantity, we have to use this quantity. And however, the impugn order, my lord, page 123 is very, it shows a calculation chart that out of this, we have received the receipts of royalty payment of this, it's just submit the proof. Lordship will kindly come to page 123. Submit the proof and go. Lordship at page 123.
No, he has not completed. Just
yes, my lord.
I'm just asking.
My lord, what happened, my lord? Here, for the purpose of construction of the road, we have to excavate, my lord.
From where?
Look, from that road itself. For bridge, my lord, I have to construct. We have to excavate. We have to put pillars. And that earth is used same place. That is not illegal digging of the earth, my lord. For the purpose of construction of road, we have to. So I say that for that royalty is not payable. Suppose your lordship find that it is payable, royalties. It's not an illegal extraction. We have not taken earth from somewhere and bring it there, my lord. And it is not commercially used, my lord, because from there itself, we have dig and there we have used there, same place.
You excavate and use it there.
Use it there, my lord. That is the, my lord, main question here. Suppose that is royalty is paid.
Whatever is sent.
Well, what happened, my lord, here? If your laws will see this page 35, my lord, 133, and this is in the first case, my lord, we have challenged. Here, my lord, they have, if your laws will find, my lord, 133 again, my lord, I shall place. Well, there is no consistency at all. This is after verification, my lord, by the BIO, Bureau of Investigation. My lord, they after verification, they found that this much quantity,
That
they
the
have
forest,
not,
forest department, forest officer.
Bureau of Investigation, my lord, they separated department, my lord, they investigated here, my lord, that how much.
No, it's a forest officer only.
DCF.
Huh?
That officer is DCF, sir. It's deputed from forest.
Deputy
Yeah, deputed
conservator
from
of
forest
forest.
department. Deputed from forest department. Now, your losses fine, my lord.
Acted as the economic offense wings.
Yes. Yes.
But it's department only,
Ah.
department officer,
Department.
not by that.
Yes. My lord, here your loss will find from the above, my lord, page 133, last sentence. From the above, it is understood that the construction company simply says that had no more documents to submit in support to the decision of forest royalty, GST IT for the aforesaid project and evaded the forest royalty so and so some below concerned quantity. Now, therefore,
This is the impute notice.
my lord,
You are challenging this.
I am challenging this one and later on, my lord, this is in the first case, my lord, when interim order was passed, then another notice was issued. Then here, my lord, after exercising power, my lord, now if you will get the chart, my lord. Forest royalty, first page 134, my lord. Your loss will find for earth, forest royalty is this much, for sand this much, and then price of the mineral. My lord, this cannot be, my lord, taken by price of the mineral. Then GST, IT, fine, my lord, 200%, fine. 200% fine. Where is it provided? Nothing is there, my lord, in Rule 64 also. Now they, by calculating, they come to 3 crore and all, my lord. GST portion is only this first clause, my lord. After the interim order was passed, my lord, the divisional force officer again issued another notice, my lord, that you will also find at page 140.
Same.
They have increased, my lord, that 15 crore. They have no consistency also. But this is after verification, my lord. This I am not, my lord, that at page 140, at page 141, my lord, you will also find. 141 last one, my lord, you will also find. They have not reacted, my lord, the document submitted also. And their quantity has been taken. 50 crore.
Now, do you had that certificate?
My lord,
showing that you don't have
certificate
to.
we have produced before the BIO. So far, the materials we have paid the amount. And then, my lord, they have issued a letter. Therefore, again issued a letter to the NHIDCL, which is at page 174. These are all focus, my lord. Here they have come down to 4 crore. Well, how they can be, my lord? 3 crore, my lord, this Bureau of Investigation has totally verified our documents. They found that this much quantity we have not paid the royalty. But we have used it from the same site, my lord. Same site. Now, the DFO issued again 15 crore and same DFO again issued the NHHCL for 4 crore. Well, these are second and third are absolutely bogus, my lord. Nothing is there. So, but BI is concerned, my lord, I am this much matter because these are next two notices are concerned, my lord. These are absolutely bogus notices, my lord, because without considering the royalty paid by us, my lord. But BIO has considered all the documents and they have come to this. Now, my lord, it is not a illegal extraction, my lord. It is not a illegal extraction, so they cannot charge the price of the material, my lord, because we have not used it commercially, my lord. We have used in the same site the extracted earth and the document. But so far sand is concerned, my lord, I'm just coming, my lord, where we have given one, my lord. That you will also find at page 118, page 118, my lord, one Tejpur, Executive India Tejpur Division, my lord, WR Division, Water Resource Division has issued us later. NOC for extraction of sand from the river, Giabrodi. With a
This is
person
not-
like no object certificate.
In relation with the construction of the guide band.
Guide band, yes, that we have taken. Guide band also, we have done it. Sand should be extracted from the river for safe distance of the so and so, so and so. Any bank protection work may be required, should be taken up by company consulted with the authorized department. The extracted sand must be used for the purpose for which it is. So here, my lord, if you also find at page 134, they have charged for earth and sand. Sand we have extracted from Diaboroli. This much, my lord, because we have not paid it. This is, my lord, not an unauthorized act. Secondly, my lord, the earth is also.
So according to you, unless it is unauthorized.
Yes.
Extraction or being using of the earth or the sand.
Yes.
You are not liable to pay.
I'm not liable to pay, my lord. Suppose I'm liable to pay the royalty, but not the other things, my lord. The fine, price of the material, GST and other things, we are not liable to pay. Because if it is a legal extraction, my lord, then only it is liable. 64 rule, 64 I have placed, my lord, that page 36. If it is a legal extraction, my lord, yes. But it's not an illegal extraction because we have done the work for the government and this is the, my lord, page 36, I have placed the rule 64, my lord. This is not illegal.
Yes, is it so?
My lord, we are
Unless it is illegal extraction, you cannot charge royalty.
royalty, my lord.
No, my lord, I'll come to that.
Well, royalty is legal only. If it is illegal, the punishment is there, penalty is there.
Fine, my lord.
Section 64 is-
200% fine, nowhere provided. 200% fine is not provided anywhere. Then price of mineral.
How,
Price of mineral.
how you are, I mean, how you pay the royalty?
Royalty, my lord, we have paid by challans. We have annexed also. Challans we have paid.
Of what?
My lord, for the art and other things, my lord, which we have purchased, my lord, we have paid royalty.
That's also
See the art,
that's also legal.
that is legal, but so far this art is
Legal, if it is legal, even if it's legal,
my lord,
you'll have to-
submitting, my lord, that we have required more art, my lord. Some art we have taken for which we have paid the royalty. But those arts which are extracted from there itself and we use it in the same work, we have not paid the royalty. NHIDCL, my lord, circular issued. And where from I have used, my lord, the same art, my lord, that I have used it. That is why I am submitting, my lord. I shall place, my lord, the judgments, my lord, in this regard. Yes,
Look, all those letters, impure letters, we are just trying to communicate that you show us the source, everything will be wiped off. It's not coming with documents, nothing. and it is own admission that a portion of the total required amount was used by them. And they also brought some other additional promoters. And regarding that letter by the water resource of NOC, water resource is not the, my lords, the competent authority. They are just issuing the NOC. They cannot say because sand is also a minor mineral.
Yes,
We have prescribed rate, my lords.
Sand we have collected, my lord, is extra sand we have collected. Water Resource Department has given us from the to collect it from Jia Boroli. The purpose of this.
What is this?
My lord, paragraph 12, my lord, at page 742.
Maharashtra.
My lord, yes, sir. 1512 is the same. 736.
Para
12.
Yes.
It is not in dispute the present that is expression of ordinary art undertaken by the appellant either for laying foundation of building or for the purpose of widening the channel to bring adequate quantity of seawater for the purpose of cooling nuclear plant. The construction of building in terms of sanction plan of MRTV well expression so to bring seawater furthermore to object of the grant in favor of the nuclear park. The appellant builder contend that there is no commercial exploitation. Well, this is the important thing. There is no commercial exploitation. We are using the same earth on the same road, my lord. Of the dug up earth, in as much as the same was redeployed in the construction activity itself. Now, this is the main question, my lord. Similarly, paragraph 15 also, my lord, it is said that the extracted earth was not used commercially but was redeployed in the building of earth. Paragraph 15 also. Same.
15.
15 also.
So your simple case is, in fact,
My lord.
that you have not used any illegal earth.
My lord.
The earth and sand has been extracted from the site itself
Site
and
itself.
reused, I mean, put
Reused
it
here.
there. There's no question of payment of royalty.
Suppose, my
I
lord,
think he is
even
a-
if I have to pay royalty, my lord, the question of,
The communication and the notice
my lord,
was direct you to provide a relevant, you show the source of, I mean, source from where you have extracted. You saw that
that I have
matter
shown,
is there.
that I have shown, my lord, that para I have shown, my lord. I have shown, my lord, para. In the table 35 itself, I have
Even my lord, that paragraph comes without any annexure to sustain it.
paragraph 23, my lord. Because we have shown various challans also for that, my lord. Because we have paid where it was taken, my lord, come on, different source. My lord. Only, my lord, in respect of the art, we will accepted from the same site, we have not paid the royalty. So there are two things, my lord. One is payment of royalty, other is whether illegal excavation. Rule 64 says that if it is illegally excavated, then we have to pay the price of the material also. Then GST other things. And this fine is, my lord, not provided, the 200% fine, my lord, not provided in the rules itself. Now I am placing another judgment, my lord.
Yes, I left the rest. Good case will not be disposed with us. That value. Right.
That's
Proceed.
My lord, this is a judgment of the Bombay High Court, my lord. I'm just not getting it, my lord. Your lordship, my lord. I shall supply it, my lord. I'm giving your lordship a copy of the my lord. I shall supply it later, my lord. Not getting it, my lord. 11.2, my lord. Your lordship, paragraph 11. High Court of Bombay. Bombay High Court. Bombay High Court. Para 11.2. You mean that 11.2 is observed by us. Yes. The present excavated material has been used by the princess for the purpose of filling up and leveling removal. Inbuilt in the course of building. But my lord, our High Court judgment division bench is there in case of Muslim Ali. My lord, so far contractor is concerned, my lord, the department cannot compel the, my lord, owner to pay the royalty unless they are in the contract. In our contract, there is nothing, my lord, that they cannot compel the NHIDCL to pay the any amount from our bills. The entire amount has been blocked by the department, my lord, with NHIDCL. Our entire payment has been paid. That we are losses will find next to be the divine path. And that has been followed. Divine path. My lord, paragraph 18, my lord, the single bench judgment has been quoted and they agree. Paragraph 18. We are in agreement with the views expressed by the single judge. No appropriation of money from the contractual use is permissible until it is backed by any statutory provision or by express provision contained the contract, binding the parties to the contract. In absence thereof, such deduction would be unauthorized. The counsel for the appellant have not been able to show any provision to persuade to take as a demand. This is para 18. And this is followed by the subsequent judgment also. Para 18. That was held by the single bench that there must be in the contract that the amount, any amount not paid, they can ask the owner my lord, to pay the amount. Oh, okay. Huh? Sir. You want to copy as never? What is exactly?
But that para 18 itself says, unless backed by statutory provision or by express provision. There's a statute covering the field, my lord.
Which particular this section?
My lord, if my lord, my seniors finish, I'll conclude, I'll address that.
Now, the same is followed in the It's okay, sir.
No.
If it's followed, it's all right.
Now, my humble submission is this, my lord, that there Bombay High Court same judgment there. Now, here, so far sand is concerned, my lord, sand we have extracted from the river as per the instruction issued by the Water Resource Department that I have placed, my lord, at page 118. Page 118 I have placed. So that extraction of the sand cannot be said to be an illegal one. Secondly, the earth which we have excavated from the site itself and used in the site itself, that also cannot be said to be illegal. Now, suppose in that earth also we have to pay the royalty. If it is not an illegally extracted earth, then they cannot realize the price of the material, GST, IT, and fine. That you will also find at page 134. Even if, my lord, suppose. And subsequently, my lord, that DFO again issued these letters, my lord, without any verification. Because the so far BIO is concerned, my lord, after he verified all our documents where we have paid the royalty. And thereafter come to this. So page 133 is the
Basis.
main basis, my lord, because other two are actually liable to both. And this is the basis, and where also, my lord, your losses, my lord, I submit that if your losses held that I am liable to pay royalty, then also, my lord, it is not a illegally extracted earth or sand, my lord. I cannot be liable to pay the price, fine, GST, etc. And fine, this 200% is not provided anywhere in that. My lord, what I'm saying.
Payment of royalty is no dispute. According to you, you have not excavated or taken it from some other place.
My lord.
You have just excavated from the same site and
Yes.
put it there.
Put it there.
Therefore, you are not liable to
My
pay.
lord. That's okay.
On the basis of the
Yes.
circular of the central government.
My lord. And moreover, sand I have extracted as per, my lord, the Water Resource Department's letter. Because this siltation was there, we have extracted the sand from there. So that is why sand is also there.
So therefore, sand also you are not.
Sand also, my lord. That
You are
is
not entitled to
not
pay.
illegally extracted. sand, my lord. Suppose in any case, my lord, it was held by your lord, then also, my lord,
Suppose it's not illegal, but it's legally extracted.
then
also-
only, my lord, royalty is payable. My lord, suppose. Maximum. Not other things, not other things, my lord.
Only royalty.
Only royalty. Same is the case in the other one also I should place, my lord, that can,
Well, that's sand. It's their own admission that they had used sand. My lord, sand finds mentioned in Schedule Y of Assam Minor Mineral Rules of Schedule Y. We are the competent authority because my lord knows settlement areas, my lord, mohols of sand and stone are floated by Forest Department. Water Resource will say, Water Resource, we normally take NOC, but the settlement of these minor minerals are done through Forest Department. And there is a schedule out there outlining how much to pay against what cubic centimeter, my lord. It's their own admission. So sand they cannot escape, my lord. So Lord, you will kindly take the Assam Minor Minerals if it's available there, my lord.
Assam. Yes, you make yourself.
My lord, I'm just giving my lord, your lord's just give it. That himself.
My lord, the rules of 2013.
Page.
It starts at page number, my lords, 245.
Assam Minor Mineral Concession Rules. Yes, then.
These are the rules, my lords. At page 246, lordship will find
240.
246, my lords. There's I, one Roman I. Department means the Department of Mines and Minerals in respect of minerals under Schedule X, and the Department of Environment and Forest in respect of minerals under Schedule Y. Then lordship will directly go to page 362.
362.
362, my lord.
Hmm.
Therein, my lord, there is a schedule Y.
Hmm?
Schedule Y is there, lordship will find at the very first top, my lord, this schedule Y.
Yes.
Lordship will find at entry number 3, ordinary sen is there, my lord.
Hmm.
It's covered under the schedule. And the rate of the schedule of lordship will find the rates of royalty at very next page, 363.
What is this? Your page 383 you just
Yes,
said?
yes, this is first schedule, rates of royalty.
Hmm?
Rate of royalty. my lord. Lordship will find therein.
Minor mill use other than in industry.
Yes, my lord.
Huh?
Yes, my lord. But first schedule rates of royalty, lordship will find entry number 4. It's 70 rupees per cubic meter.
Hmm. Then
My learned senior has admitted, my lord, in course of his arguments that they have used sen. Perhaps that will take care of the facts, my lord, regarding what is sen, my lord.
no, send he said.
Then he said use, but he
Use,
said
but then it was on the basis of the
water resource has to give a NOC because, my lords, it's regarding the effect. When somebody digs sand, my lord, the water resource, that it affects the river bank. That's the reason he goes for, my lords, the NOC of the water resource. In fact, when we float tenders for settlement of that mining areas, my lords, mining areas mostly, my lord, that those catchment areas in Lakhimpur and Sunitpur, my lords, we used to take this NOC from the water resources before inviting tenders for settlement. So, my lord, lordship, I have pointed out that for the sand is a minor mineral, falls under our schedule, and there's a royalty rate prescribed.
What is it?
Royalty rate, my lord, will find that page 363.
Minor minerals uses and what is ordinary sand?
Ordinary
sand for prescribed purposes.
70 rupees per cubic meter.
Where is it?
Lordship, 363, the page starts with the word first schedule. The book, I don't have the same book.
Sand not to be treated as minor, huh?
Lordship, there's a schedule of it.
Page?
My book is 363.
363. This one? There must be old one.
That must be. But lordship will kindly. এখন কষ্টটা কোনে গ্ৰীণ কালাৰখন ই চাগে ভাৰ্জনটো হলাই দিম in lordship's book it's 364
360. That's
364
what I said.
364 well we'll catch up the publisher, my lord.
No, it's your fault. You are using the old book. There must be lots of amendments and the addition. That's why it's 360.
Lordship, yes, 364, lordship pages 364, lordship find there and there is an entry at serial 4.
Ordinary sand other than sand used for prescription. Yes.
Yes, 70 rupees per cubic meter.
Okay. Then,
my lords, that Muslim Ali, lordship, the paragraph 18, is written unless backed by express provision in the contract or a statutory provision. There is a statute. This is a statute. And that apart, my lords, as I'll keep it very simple, my lord, that Muslim Ali, everything has been, my lord, has been dealt with by division bench in writ appeal number 258 of 22, my lords. Therein, my lord, a proposition was forwarded that the contract agreement.
Assam ko chahiye na. We need Assam.
That contract agreement of PWD didn't indicate anything of deduction about royalty, forest royalty. And in that background, Muslim Ali was pressed into service by the petitioners, appellants. But the fact situation was there in bit different because there was reduction of bill. And in this case, my lords, it's a railway contractor. When he came to the court for realization of his bills, my lords, we insisted no. You first give other you demonstrate that the source of the material used in your contract is a legal source. And my lords, that stand of department was upheld by the revision bench. My lord, kindly have the paragraph 11, my lords. There in my lords. Shall I read out, my lords? Para 11.
Para 11.
Para 11. The main submission of the learned counsel for the appellants in reference to the condition so and so of the contract was that ordinary art was not covered under so and so of the document. The employer railways was not at liberty to demand the forest royalty clearance certificates from the appellants regarding the said mineral used in the construction works. However, we are not in least impressed by the said submission for the simple reason that clause so and so referred to in supra is not exhaustive in its separation because it only refers to sand, stone, and timber in generic sense as covered under forest producers. The governing phrase of the said clause is forest produce. Examples of so and so, my lord, it has been clearly held by the division bench of this court in the case of G.H. Vijapura that ordinary earth, even if extracted from patta land or non-forest land, is liable to levy of royalty. As undeniably ordinary earth has been used by the contractors for carrying out the works in question, proof of royalty being paid would have to be provided by the contractor to the employer before the bills can be paid. In this background, my lord, the notice dated so and so issued by the employer to the appellants, herein requiring them to present the FRCC forest royalty clearance certificate cannot be termed to be illegal or unjustified in any manner. Thus, requiring the appellants herein to present the forest royalty clearance certificate for the components of ordinary art and boulders cannot be considered to be beyond the scope of standard document contract, so as to warrant interference. The learned single judge has already directed the employer to conduct verification of the contracts and to determine whether forest royalty is recoverable, and only thereafter the follow-up action has been permitted. The read appellants cannot claim to be prejudiced by the aforesaid directions, with otherwise so also a standard scrutiny of law. Well, I'll fall back to again that document of my learned senior, that page 123 of the petition. We are insisting you come and show the proof. Page number 123.
Yes, well.
Well,
Yes.
that page 123, my lord, the impugn order of the petition.
121.
123. 122, it starts. Annexure 7.
123.
Yes, my lord. At the bottom, lord, you will find just above the signature of the officer.
You request to submit the proof of the above mentioned
Yes, my lord.
payments
That's all.
accordingly by 10 so and so.
That's all, my lord. if you have done so and so work, you have extracted, you have admittedly they have used. That part also I forgot, that some portion of the excavated earth, a purported excavated earth they used from that place only and then they did that. But the judgment, my lords, the division bench says either it's you from, if it is from even non-pata land also, private pata also, is leviable of royalty is leviable. My lords. In fact, we are not insisting that on that. First, just come and show us the proof, my lord. Because if lordship, if I go back to para 35, that is their own admission that out of this portion of material X and Y, we have given royalty of this amount. Then these other, because there's a calculation chart, also you will see at page 122 again, my lords. We're not denying they have paid certain amounts. The first column, my lords. 130, yes. Oh, what? No, 130. 33, no, 122 to provide. Lordship at 122, they have admission, they have utilized earth soil, so for which documents submitted of definite quantities there. Then we find there's a there's a deficiency in the whichever days they have paid, we have admitted they have paid. But when it's found out the total accumulation of the mineral used by them, there's we found out that our records do not reveal that they have
Paid the entire royalty.
my lords, entire royalty, my lords. If they show us the proof, my
For the
lords,
quantity they have used,
yes, my lords,
they have not paid.
not paid, my lords. Some portion they have paid.
Yeah.
That is admitted, my lord. So in order to ascertain that, my lord, they are just required to submit the proof. Submit the proof and they can go. And regarding that, another aspect raised by my learned senior, my lord, that rules don't contemplate. That's 64 one, rule 64. Oh, page 6. Page 36 of time. 64, my lord, there is a sub 3. It mandates, my lord, for
Rule 64.
64(3).
Yes.
My lord, the mode therein, my lord, is mandated as to fall back to section 21 of MMDR Act of 1957.
Wherever person is found to indulge in such offense for third time or more, the officer concerned shall register. What do you want to say?
My lord, that very purported extra component that we have GSTs there, these components there, which has increased the material price, so-called penalty to be imposed, my lord, that section 21 of MMDR, my lord. It stipulates, my lords, in that very book, my lords, if I there's a paragraph, there's a section 21. Section 21, my lord, perhaps lordship's book will be now page 41. Lordship's book, it will perhaps page 41. Penalty section is there, penalties are there. Rule 21, sub 5.
Act or rule? Act or rule?
Act. In act, Act section 21. Okay.
1957 Act.
Yes, my lord. Act.
Penalty,
Rule 21. Section 21, sorry, my lord. Section 21.
Penalties.
Penalties, my lord. Therein, my lord, lordship will find sub 5. A component will get. Whenever any person raises without any lawful authority any mineral from any land, the state government may recover from such person the mineral so raised or where such mineral has already been disposed of, the price thereof, or may also recover from such person rent, royalty, or tax, as the case may be, for the period during which the land was occupied by such person without any lawful authority. Now, what had happened, my lords? Had he not used that sand, my lords, we could have given it into settlement to the Mohol. When, my lord, the mode of operation is such, at page 141 of the petition, lords will find this, the breakup of the fine so imposed.
Have you filed the affidavit?
Yes, we have filed. But in one, we have only in one case we have filed.
Item
That was
33.
The lead case, my lord.
That will
5631.
that will cover only difference is the amount and the total amount
is
and the
different, but we have stand is same almost.
33 and 34 to same amount, construction site, everything.
The amount is different. I said just place the
amounts are different.
Item 33,
item, there is
34.
only, my lord, there is only art material.
No, see 33 and 34
33, 34 same, my lord, 30,
same.
because 34.
Only the difference is that there was two notifications.
No, my lord, two demands.
Two
The
demand.
subsequent demand we have annexed in the 34, 33.
That's all.
First demand was 3 crore and all, then they raised it to 10 crore, then it comes down to 4 crore.
44.
4 crore.
4 crore.
4 crore.
In
That is
second,
what was challenged.
second demand.
Second demand, my lord. Second demand is gave out without verifying, my lord. That so far this my lord, BIO concern, it has verified all.
So total demand is
So 3 crore and all. The other, my lord, they are to be liable to court. This is the main demand where they have filed the affidavit also, my lord. In the affidavit also, they have said that they have verified the documents.
then 35 is
35 I shall place, my lord. I shall take only 10 minutes, my lord. I shall place.
35.
I shall place. Now,
Same,
my lord,
it's not
what-
same.
My lord,
It's not same.
same, my lord, only, my lord, difference is, my lord, I am placed.
Difference is only the amount.
Yes.
No, if the amount is different, it's
I'm
okay.
confident.
It's okay. Let us do one thing.
My lord,
Sir, I would request to file a written submission.
my lord,
No, list. Short one.
my lord, they are, my lord, this, written, yes. I shall give it.
Well, what?
What?
Anything? Mr. Borua.
Borua is the main troublemaker, my lords. Borua is the main troublemaker, my lords.
He's making me main. But it is, I'm not me. What happened is their inspection is there. Contacted, is APC contact, engineering query, whatever they have to follow that.
Is your contractor?
My contractor, but
Who has to pay? Contractor or you?
I pay, no, this all.
You will deduct this
Because
from
it's
his.
to be paid by contractor.
Ah.
Only my bill amount has been withheld because of their letter that you don't pay this amount because this amount to withheld, make withheld. and you
Okay.
don't pay. Accordingly, we are withholding only this one. Now, forest department is saying you pay, or lordship say, yeah, they pay, we'll pay. We
Okay.
don't have any problem in payment.
You are
They're
ready?
waiting
You
for the lordship should direction, do you pay this amount? Or forest department should do clear stuff. That's what it is already limited. And these all payments to be made by under EPC provision, my lord.
So he has to pay, but then
Yes,
you
all
have
This expenditure he has to pay.
you have held up his bill because of this.
Due to their letter,
Okay.
forest department letter.
Once the writ petition allows, if the writ petition is allowed, then you will pay him. If it is dismissed, you will pay to the forest.
The lordship will give direction to forest department. They, do you enjoy your letter, which is being given to an citizen.
So for the convenient use, both of you may submit the.
My lord, I shall submit it by Monday, my lord.
Monday.
Monday.
I'm not going to pay.
Okay.
I'll let it.
Okay.
Submitted by.
So
So
we'll
he
just-
he has to bring in one thing, my lord, that very submission he made, that he has to pay everything. He has to, that contract specific clause where the contractor has to pay, he can
Yes,
give it,
yes.
my lord.
That's a
Everybody
very,
go.
very clear now. What is about Miller? This EPC, engineering procurement, I have already stated in my affidavit. This is called engineering procurement and construction. This procedure, as per this procedure, that we have already clearly said our affidavit. This is to be paid by the all expenditure. Affidavit is the board, and my affidavit is there. I'm saying affidavit, I'll give you. This is the procedure, Miller. That is not for this case only. When EPC is there, earlier what happened, we used to pay a bidding. Now this mode of construction is been different. We are giving all EPC mode, not only this case. EPC engineer procurement, whatever expenditure is required, where is it required to be paid, everything is to be paid by the contractor. That is our EPC mode. Lordship, we went. Oh, yes, yes.
Okay.
My lord.
We'll just fix it on Monday. No, not for any argument. Only for, or we'll see, keep it CAB.
Yes,
That
that
is
will
better.
By Monday you submit.
Monday.
And
We heard Mr. GN Sahewala, learned senior counsel assisted by
HK sir.
HK Sharma, learned counsel for the petitioners. And also heard Mr. Which one? Respond number one. D. Gogoi. Learned standing counsel Forest Department for
I am for, my lord. Respond number 1 to 4, my lord.
1 to 4.
No. 3 to 1 no, na? Huh? 3 to 1 no, na? DGP no. I am 1, 2 and 4.
1, 2, and 4.
I'm for
DGP no, I do. Deputy Commissioner of Forest.
No, 56312.
5 and 6 I want to
5631. Petition.
Oh, 5631.
I'm for NSADCL.
I am for Forest, my lord. Deputy.
Standing counsel NHIDCL.
C. Borua.
C. Barua. You are deputy commissioner.
Right, Forest Department. So, one like one.
Hearing concluded, judgment reserved.
One of them.
I can take the book, my lord. I shall give the
Yes,
extract.
yes.
Extract I shall give, my
You will
lord.
get that thing.
Extract I shall give. I think it is in
You
the
will just
library,
get
my lord.
that. You find out. This book you find out will be required. All right. But so by Monday,
By Monday.
you kindly ask your
My
auditor
lord, I
to
shall-
file
Yes, sir.
the written submission.
My lord, you will-
Not lengthy one.
No. Ekdam short, my lord.
Huh.
Absolute short. I told you have a shortcut in my mind, my lord.
Huh?
Just modify my affidavit.
Not that. Whatever your written submission or not.
Oh, a book is there, my lord. They got it.
Dispose of but CAB. That's all. CAB. Judgment, hearing concluded, judgment